I beg to mention item number 21 for withdrawal. For withdrawal the matter.
Your name?
And they.
No. Ms. MD, the legal counsel appearing on behalf of the petitioner submits that she has instructions to withdraw the petition. Accordingly, the petition stands closed on withdrawal. Interim order, if any, stands vacated.
May please, your lordship. Lordship, I beg to mention item number 14, your lordship. It's a contempt matter, your lordship. The order has been complied with, your lordship. I have received instruction from my client.
What item number?
14, your lordship. The order has been complied with, your lordship. My client has received the money, your lordship.
What's your name?
ST Bucks, your lordship.
Ms. S.K. Butt, the legal counsel appearing on behalf of the petitioner submits that the judgment order dated so and so, passed in WPC number so and so, have been complied with. Considering the above, the incident proceedings therefore stands dropped.
Well, I appear for the respondents. The affidavit has been filed, bringing on record the
Mr. Deenak appears on behalf.
lodging.
Lordship, I beg to mention item number 17, Lordship. This order has been contempt matter, Lordship. Order has been complied, Lordship. Petitioner got relief, Lordship.
Take your order. Your name?
P. Sharma.
T.
P. Sharma.
You're not there in item number 17.
OP Bhati on behalf. OP Bhati on behalf.
Not at your instance.
Lordship, I beg to mention item number 19, your lordship, with the consent of the petitioner, your lordship. May be kindly adjourned for the day, your lordship, any day on the next week, your lordship.
Why?
Lordship, we have sent our affidavit for waiting, your lordship. That is yet to
See,
be
when the
received.
matter reaches, it has come up for orders, it has come up with an office note. So we'll have a look at it, why the matter has come.
Yes, your lordship.
Lordship, I beg to mention item number 38, Lordship, 38. Lordship, in this matter, we were supposed to file our affidavit.
I don't entertain this type of prayer at this hour.
Okay, the same thing. That will be available.
We'll see when the matter reaches.
Okay. But Lordship has directed the District Commissioner Kachar to appear for VC. But we have also filed an affidavit in the matter. And the amount has been released. We have brought it on record.
Where is the-
But we could file the affidavit yesterday. I have called for that. If this is an extra copy.
When did you release?
On 7/6.
7th?
7 Lordship.
7th of May.
Lordship.
You have released it.
Yes.
Why such a late?
But
release?
in fact, in paragraph 3 of the affidavit, we have said, the present incumbent, he has joined in the very recently. Because of some the election process was there and some verification process was there. Because of that, some time has been taken. Paragraph 3
This is a matter pertaining to land compensation.
it is Jirat, the compensation relating to Jirat. That
Obviously, Girard.
Lordship.
That also comes within the land
Lordship.
compensation. Then under such circumstances, when the money was deposited before you on 23/9/2025,
25.
why it took another 6 months, another 5, 8 months to do it?
But in
Who's
fact,
going to pay the interest?
Lordship, I kindly consider.
No, somebody has to pay the interest. He's entitled to the interest as per law. The interest would be as per what, 15%?
Malabe kindly consider for this
You
time.
see, somebody has to pay the interest. What do you say, Mr. District Commissioner?
Good morning, sir. Sir, we very humbly submit, as was mentioned by my learned counsel, that I had joined in the month of January, and in fact, the entire revenue team has very recently been moved out, and a new team has come in the month of January. So, because of that particular reason, this got a little delayed, and from March onwards, our entire revenue team, including myself, we were busy in the preparatory works of election. And entire March and April went in that, and because of that, we looked at this delay of around 3 months at our end.
Mr. District Commissioner, I understand that, but the fact remains out here. When it is a land compensation, there is always an interest aspect involved. Isn't it?
Sir, but
If
this,
the interest in aspect is, if you see, if this is being an acquisition carried out under the Land Acquisition Act 1894, or if it is done under the Assam Land Requisition or Acquisition Act, then the interest component is there. How do you take care of it in releasing the amount so late? Because admittedly, in the month of September 2025, you had the land, had the money with you. A delay which is being made on the part of the district administration in releasing the amount is in fact it amounts to taking away the petitioner's rights out here for the amount, and that too this is a matter which is a case of contempt when there was a specific direction to make the payment.
sir,
This is a serious infraction to the duties which is reposed. I don't blame you, taking into account that you may have joined recently. But you see, this is a thing which these people also have the rights. And filing a contempt out here to get the amount which is there, it doesn't suit. And if I had not passed the order on 6/5, you would not have released the order money even on 7/5. So I think something needs to be worked out. Brainstorming needs to be done. I have seen, not in your case, in many other matters also, it is taken that, okay, we take it. At the end of the day, it is the state who has to pay the money. The interest the state has to bear from the public exchequer. The money is yours, mine, everybody's money, because we all pay taxes. That's the money which the state is paying. I'll ask you not to repeat it, or not, your office also not to repeat such things in future.
noted, sir.
But this is a race, Mr. Nath. The thing is not like that. The thing is, if you don't make the payment, he has a right of interest. It's a statutory right.
Correct.
And if this right is being taken away, this court will be compelled. At the end of the day, because of some officials not clearing the amount, the effect is felt by the public exchequer.
True.
So,
That's very true.
first of all, you need to take a note. If you don't have the money, don't go for acquisition. This is the most important thing. Don't think that tomorrow we'll get the money from somewhere. And then first you have to have the money, then you go for acquisition. Because otherwise, the main problem is the interest. And interest is fairly high. It's 9% for the first year and 15% from the second year. 15%, nobody. If a person, if it is the petitioner, he would be otherwise happy if the government does not make the payment. The reason is, if they don't make the payment, then there will be an interest which, if he keeps it in the bank also for twice the period, he would not get it.
Well, absolutely. No, I have suggested them to look into this kind of matters seriously.
You have tried all the other officials also.
Correct.
Now, I've seen many cases where reference applications are filed. Now, reference application, what is required to be done is immediately the authority, more particularly the district commissioner out here, he has to refer it. The moment you are delaying it, if there is an enhancement, as per section 28, there will be further interest as per 9 and 15. And that is at the end, that is again at the cost of the state exchequer.
That's true.
And this interest is never a planned expenditure. Because when you go for an acquisition, you think, okay, for Jirat, this amount, this will be for the 12%, which is required during the period from the date of the notification till the date of the award. And further, an amount of solatium, which is now 100%, earlier it was 30% to the effect. This is the basis on which you plan and take it up. Now, if there is a reference procedure, delay in making a reference, it in fact, if there is an increase by 100 rupees also, there is an accumulation of the interest from the date of taking over the possession.
Correct.
So you have got the money.
Only 10 lakhs, Lordship, no interest. And in the order, there is a clear order, in paragraph 8, Lordship.
No, no, after deduction
It
of,
is needless to say that the amount of question would also carry interest as per the statute governing the
Where?
para 8, page 17 of the High Contempt.
Where have you got the money? How
Uh,
much money you have got? 11 lakhs.
Out of that, Lordship, only 10 lakh something received by the petitioner.
after that, there is some deductions, statutory deductions maybe, Malad. And whatever amount to 4 petitioners, this has been paid.
When did you get the money?
Lordship,
7. Okay, you do one thing. If they given less amount, then you go for reference.
Lordship, there is a clear direction by Sunadu to the para 8, interest.
Where?
Para, Lordship, page 17, para 8.
With due respect, Mr. Majumdar, the learned coordinate bench was wrong. The thing is like this. The deputy commissioner makes an offer. What's an award? He makes an offer to you. You want to take up this money, you take it. You may accept it under protest. And thereupon your recourse is, if it is done under the Assam Land Acquisition and Acquisition Act, it will be a recourse is under section 12.
Lordship is under.
No, what is the business? You see, the district commissioner, after passing an award becomes functious officio. He cannot award an interest beyond what is given. He cannot take into account a representation because he becomes functious officio. You are aggrieved by that, then you have to go before the authority concerned, file an application under section 12, and the district commissioner would be kind enough to refer it to the district court, wherein they will consider as to whether you are entitled to this amount inadequate. That is the only thing you can do. But the fact remains that the district commissioner has no business after passing an award. It is final for him because he is making an offer on behalf of the government. The district commissioner works as an agent of the government and gives you this money. Okay, we are going to give you 100 rupees or 200 rupees. And after that, you are agreed. You may take it under protest and then file a reference under section 12 if it is done under the Assam land. But under no circumstances, this court is
Lordship,
going.
land acquisition.
And this is being done under the Assam Land Acquisition Act 1894.
1894.
So 1894, kindly see section 18. So therefore, the award which is there, you have to go there. You cannot, under no circumstances, this is an order with due respect, couldn't have been passed because he is functious official. He cannot pass, he cannot adjudicate anything once he passes the award. Because then if he does so, he will be transgressing upon the authority reposed by the government to acquire on behalf of the government. So the whatever amount you are getting, if you are aggrieved, you go and file whatever application you file. It's your lookout. But this is the amount, this is compliance. Because what has happened? The court directed that, okay, you submit a representation and they will consider and also include interest. Whether they have included interest or not, I'm not aware of that. But the fact remains that you have been paid certain money. If you are aggrieved, then obviously you know what course of action is there.
Lordship, awarded amount. Lordship, kindly have a look at page 16. That the awarded amount 11,41,660 square.
Where?
Page 16.
Page?
Page 16, Lordship, of the order. Para 4, page 16. 11,41,667.
So the awarded amount that whatever may be, if you have got less, why the amount has come down?
Because of some.
Yes, Mr. District Commissioner, why the amount has come down to from what was mentioned before this court earlier?
Sir, sir, the total award amount was 11.41 lakhs, and out of that we have statutory deductions of administration charges and establishment charges. Only those two have been deducted, and thereby we have arrived at the final amount of 10.37 lakhs, which has been paid to the petitioner.
But am I not? You see, when you submit your proposal for acquiring a land, at that point of time, don't you mention that you see the value of the land is this much? And after the value of the land, these are as per the Land Compensation Act, this is the amount, and remaining, this will be 8% would be the establishment and establishment charges. So if the awarded amount is mentioned as 11,41,667, can you deduct from there 8%?
Sir, that is the sir, for Zerat, that is how we usually compute the amount, that we arrive at
No,
an
you
amount.
don't deduct it from them. Let us see the award. Where is it? Where is the award?
Lordship, this content is an award is actually not there. Lordship. Page 16.
Page?
Page 16. Total amount 11 lakhs.
It's a recommendation, not even an award. Have they passed an award?
No.
You have not passed an award.
Sir, the award has been given, sir. It was given by my predecessor.
Award was passed.
Yes, sir. It was passed by my predecessor.
Okay, can we have a copy of this award? You see, a recommendation made by you is different from an award.
And that recommendation made in the year Lordship 2005. But Honorable Court, while dispose of the writ petition, make a clear direction that on receipt of the representation, they could make a pass an appropriate order, including in.
He cannot pass an order further. Problem lies there. The jurisdiction of the collector is limited. He is only given an offer to you. If you are agreed by that, therefore you ought to have gone before the reference court. We can't reopen this thing. And more particularly when section 18 category 18.2 categorically mentions that you have to do it within 6 months. Either from 6 months, the latest period is 6 months or 6 weeks if you are present when the award was passed. This is the law. We do one thing. You have already paid some 10 lakhs. How much?
Well, the rupees 10 lakhs 37,878.
10 lakh 37,878.
Page number 30, in the affidavit. Page 30.
Page number
30, Annex 1.
P0. What is the name of the petition?
There are four
Yeah.
petitioners. The first petitioner is at serial number 3.
Okay. So these four.
4.
So you have paid this amount.
Yes.
Once you have paid this amount, then if he has anything out there, then we have to give him the liberty
Malak.
under 18.
Yes, Lordship may give them. Lordship may give.
I give
There
you
are
the
10
liberty. If you have anything, you go and ask.
Lord.
Because the interest amount, you can very well ask, it is inadequate. which you have come to learn now in view of this amount. It is benefit. Now, Mr. So-and-so, the District Commissioner Kachar is present pursuant to the order passed by this court on 6/5/2026. The present application is filed alleging willful and deliberate violation to the order dated 23/11/2022, passed in WPC number 3463/2016, whereby there was a direction upon the district commissioner, whereby the learned coordinate bench of this court granted a liberty to the petitioners to file a representation within 15 days. And the district commissioner Kachar was directed to cause an inquiry regarding the status of the payment of the evaluated amount, and he found that any amount is payable to the petitioner, the same be released to the petitioner within a period of 2 months from the date of receipt of the representation. On account of no payment being made, on account of the payment having not been made, in spite of submission of the representation, the petitioners have approached this court by filing the present contempt application. The record reveals that this contempt notice was issued in the instant contempt application as far back as on 8/9/2023. The record reveals that on 6/5/2026, when the matter was taken up, the instant proceedings were taken up, the attention was drawn to this court to the fact that the executive engineer PWRD the record revealed that the amount of rupees 11,41,666 have already been deposited to the account of the district commissioner Kachar. And there was a confirmation to that effect as on 24/9/2025. Under such circumstances, this court took up the matter as to why, in spite of the amount being available in the account of the office of the district commissioner, the payment of rupees 11,41,666 was not made to the petitioner. This court also therefore sought the personal appearance through the video conferencing link of the district commissioner, Kachar. Pursuant thereto, it is seen that on 6/5/2026 itself, the district commissioner Kachar have informed the branch manager of the Punjab National Bank Silchar branch to arrange e-transfer of the sanctioned amount to the petitioners. It is also being informed that an amount of rupees 10,37,878 have already been disbursed to the petitioner. Taking into account, this court inquired with the district commissioner, Kachar, as to why the amount was reduced from 11,41,666 to rupees 10,37,878. It was informed that the amount have been paid to the petitioners after making the necessary deductions towards the establishment cost and processing expenses. Taking into account the above, it is therefore the opinion of this court that the judgment and order passed by this court dated 23/11/2022 in WPC number 3463/2016 stands complied with. Accordingly, the present contempt application proceedings stands dropped. It is however observed that the dropping of the instant contempt application shall not affect the petitioner to approach the district commissioner, Kachar, under section 18 of the Land Acquisition Act 1894, if so advised, within a period of 6 weeks from the date of the present order.
Alright.
The personal appearance of Mr. So-and-so, the District Commissioner Kachar, stands dispensed with. Okay.
Thank you, sir.
Mr. Bhuya,
My lord.
this is matter about.
Lord, the matter about, my lord, I had been entrusted with a work order, my lord, for the construction of for the development of the boundary of, my lord, the Kamrup Jila Parishad Rural Office, my lord. And thereafter, my lord, I had executed the work up to 70%, but my lord, till date, not a single payment had been made to me, my lord. And now, my lord, the project is also stalled. I just want to draw my lordship's kind attention to only one annexure, my lord, which reflects the regarding at page 55, my lord.
So what is, this is the case for non-payment of dues?
My lord, exactly because the works has not been 100% completed yet, my lord, admittedly, my lord.
Now, has
So-
the work been given up?
Yes, yes, no, my lord, I have not given up. If my lord may be pleased to take up page
Is the work
55,
pending?
it is still pending stage, my lord.
Then
Now,
yeah.
no, my lord, because
For running bills, if we are going to look into it, then how
No,
what
my lord.
happens?
No, my lord, we say, my lord, in this petition, my lord, my prayer is that, my lord, the amount which the works which I have been completed, my lord, in along with that, they should make endeavor, my lord, to make the necessary arrangement for the purpose of completion of the work also.
Let
my lord.
us see the work order.
My lord, yes, my lord, it is at page. The work order is at, my lord. Annexure 2, my lord.
Now, this is a notice to
No,
proceed
no.
with the work. Where is the work
My
order?
lord, may I kindly turn to page 34, issue of notice to proceed with the work, my lord.
Hmm.
And then, my lord, another is at page 35 is the formal order, my lord, land development with construction of the boundary wall and drainage system at proposed new office campus of Kamrup Jila Parishad Amingaon, my lord. So it's also carries some public importance also, my lord. There is no office such, my lord, at till date.
Is PNRD?
PNRD, my lord.
But where is it? Normally, these work orders are being issued that we'll make the payment when we
My
have
lord.
the fund available.
Yes, my lord.
If I issue a notice in these type of cases, then we could have a big problem.
No, my lord, I just, my lord, what is the present stage, my lord?
PWD has given it. Huh? PNRD is a party.
Yes.
Name not reflected. Okay, taking into account that the name of the standing council of the PNRD is not reflected in the cause list, list this matter again
My
on
lord.
Monday,
My lord.
showing the name of Mr. S. Dotto, the standing council of the
PNRD.
PNRD in the cause list.
We'll serve also a copy in the meantime. We'll also serve a copy in the
We have
meantime.
not served,
We have served, my lord. We have served. During filing, that's not possible.
not you, PNRD. PNRD has the, have you served copies or
Yes,
not?
yes, yes, my lord. My lord.
Is the PWD there?
No, my lord. PWD has no role, my lord. Kamrup Jila Parishad and PNRD is the, my lord. Panchayat role. My lord.
This court have also taken note of that the PWD is not a party to the instant
Yes, yes.
proceedings. Accordingly, the registry shall make necessary corrections.
My lord. Obliged.
So we are challenging the order dated 24/3/26 passed by the regional PF commissioner.
Huh?
my lord, this matter had earlier come up to your lordship's bench, my lord. What had happened? They have charged us interest and damages, in spite of the fact that the amounts have been paid on time. Only the difficulty is that, my lord, may come to page 164.
Yes,
My lords will see.
I remanded it back.
Yes, my lord, that order was set aside. Again, the same order has been passed. Now, difficulties, my lords, will see for the month of
Set aside.
January 11.
You have not decided anything on the Extent Provident Fund Commissioner who does only directed to consider the applications of by the Commissioner on the same preparation. Was an opportunity given?
Yes, my lord. Opportunity was
When?
given. The same order has been passed. My lord, the difficulty, my lords may come to kindly come.
Where the order?
Order is paid 170.
Revised order passed under section Iman, whereas in an order passed initiated by this court under so and so. Damages of Ia under so and so, and penal damages of Iman under so and so, by judgment in order to so and so. And set aside the order and remand the welfare according the dispose of the communication was set aside. Hearing. Whereas in compliance to the Yasman partner of host. Pursuant to the order of the that is given from the to justify the establishment claim of delay in deposition of the Yasman establishment being charged about it. Well, you have an appeal against that?
No, my lord. There's no-
Why?
There's no
There
provision.
has to be an appeal by these authorities. Provision regional, this is passed by the regional provision fund officer. There has to be an appeal. This is done under which provision?
Under the PSI.
14 of the Employees Provident Fund Act also. In B. Power to recover damages. Let us issue a notice, we'll look into it. Issue notice making it returnable on. Why no Union of India Council? There's no council for Provident Fund, standing council. Mr. M. Setia. There's no standing council for Provident Fund. Who? Earlier, who appeared in this matter? J. Sharman as the Ms. J.
J. Sharma.
Yes, I told you, 7-1. Remember, why you are saying that there is no power? 7-9. You have provision fund? We dismiss it right away. Mr. Datta, you are union. Yes, I was in begging. We dismiss it. On the ground that first you say that you must not have read this. Because the moment I read that my order, then I remembered. This is a review. Against that review, there is no review, therefore this court interfered with that order. And therefore, I said that kindly look into that. And thereby directed them to look into it. And an appeal lies under, and the moment the review order is passed under 7B, except an order of rejecting an application for review referred to in the Iman or section 3 or 14B. So 14B is there. Go to the industrial tribunal.
7Q, my lord. The order has been passed in 7Q.
We dismiss with cost, Mr. Sahewala, for misleading this court.
I'm sorry.
Why on earth you have mentioned to this court that there is no appeal?
My lord, I'm sorry.
I was under an impression, luckily I saw my order. We trust the councils when they make the submission, and that too of a person of a stature of yours.
My lord, I'm
Why
sorry.
on earth did you make that submission?
I'm sorry.
We dismiss with cost of 50,000 upon you, not upon the client. Heard Mr. A.K. Sahewala, the learned counsel appearing on behalf of the petitioner. Mr. A.K. Datta appears on behalf of the respondent numbers 1 to 6.
My lord,
1 to 6. The present writ petition has been filed challenging the order dated 24/3/2026, passed by the Regional Commissioner, Regional PF Commissioner, Roman 2 PD. That is the respondent number 4, whereby in exercise of the powers under section 7A, read with 14B of the Employees Provident Fund and Miscellaneous Provisions Act 1952. The petitioners have been directed to pay to the establishment the amount of rupees 2,27,076 under section 14B and rupees 1,14,717 under section 7Q within 15 days of the receipt of the said order. It was further mentioned in the said order that the event of failure of remittance of the above dues within 15 days post of action, recovery action as per provided under section 8B to 8G of the Act of 1952 shall be initiated without further notice. This court duly takes note of section 7(1)(I) of the Act of 1952, whereby there is an alternative and efficacious remedy available before the industrial tribunal constituted by the central government under subsection 1 of section 7A of the Industrial Disputes Act 1947. Taking into account that there is an alternative and efficacious remedy, and this court does not find the present writ petition to be a fit case to be entertained. Accordingly, the writ petition stands dismissed. Full stop. The dismissal of the instant writ petition, however, shall not preclude or prejudice the petitioner to approach the industrial tribunal if so advised. Yes.
My lord, this is regarding, my lord, non-payment of liabilities. And pursuant to certain work order, my lord, petitioner has
Work order of the year,
2020, my lord, pays.
non-payment.
Yes, my lord.
Which
Pay-
department?
My lord, Water Resource Department.
Water resource. You are there.
Lordship,
This is a work having any relation with Ministry of Jal Shakti?
May not be, your lordship. Therefore, that I have to take instruction, your lordship.
Okay.
and my lord, liability statement is there in page 30 annexure 6, my lord.
Lordship,
I'm not-
I have one submission, your lordship. As per Kamsar your lordship, liability statement should come from the chief engineer, your lordship. And
No, I'm not on this. You don't apply with Tamsir Ali with you. Tamsir Ali is a PWD man.
there is one standing instruction directing all executive engineers not to issue liability statement.
And
because-
no, don't include on the basis of the executive engineer. I'm only issuing a notice.
Yes, sir.
Don't go as per the, I'm not going to go as per the liability statement, no.
Yes.
And in fact, I told all the, I think the PHE department, I called the secretary once and told them, kindly impress upon your, all your secretaries that these executive engineers should not be issuing this liability statement. But then also, I think your water resource department secretary must not have informed. Nowadays, PHE, they don't issue. PWD, they don't issue. Now, this is the problem which happens. Old matters, sometimes those matters were pertaining to 2009-10. He comes up and gives a liability statement. And later on you find out that this executive engineer is not there later on. Okay, issue notice making it returnable on 7/9/2026. Ekini bagi kini likini.
My lord, 4 and 6 same, my lord.
Huh?
4 and 6 same.
Period
Same.
2020.
Lordship.
7/9. Mr. Hawk, is it Ziaul Pasa or nowadays anybody else? Oh, yes, Ziaul Pasa. Yes, tell me. What has happened to him? Passing the interim notice to proceed with the work dated 10/3/2000 issued by the chief engineer so and so in favor of the respondent number someone. Yes, tell me. Oh, that day.
Yes, my lord. That affair was
Ah,
also not registered, my lord.
okay. Why are you standing out here? It is the PWD who has to do it.
PDC also can't be that right.
PWD, you have no business out there. Here is your case that this person concerned did not allow you.
Yes.
Now, did you file an FIR?
Yes, my lord.
When?
Page 30, my lord, on the same date, my lord. Page 30, it was sent to
Have they registered the FIR?
not registered, my lord. It was sent to the SP.
Now, have you made the SP a party?
Yes, my lord.
So you submitted the online
Online
bid,
bid, yes, my lord.
but you could not submit the
Submit
hard copy
hard copy of the bid, my lord.
on account of the respondent number seven's
Yes, ma'am.
person
Of study.
have stopped you.
Yes, ma'am. And subsequent that, uh, my lord, notice to proceed the work, my lord, that was issued in favor of the respondent number 7. The respondent number 7, my lord, who had obstructed me, my lord, from submitting the hard copy, my lord, he was allotted the work, my lord.
Okay. We'll issue notice and ask them to file, get their instructions and ask the SP
Right.
as regards what he has done in respect and what is the incident to submit a report as to the filing of the FIR and all. If there is some truth into that incident, obviously you have been stopped.
Right.
Then we'll have to pass necessary orders.
Right.
And then obviously they would not be supporting
Yes,
the respondent number 7 if there is truth
Yes.
into their allegations.
but
Better, I hope you have drafted your petition in that manner.
Yes, my lord.
Issue notice making it returnable on 22nd of June 2026. Mr. B. Gogoi, the learned additional
one to six.
Advocate General, as well as the Standing Counsel of the PWD Department, accepts notice on behalf of respondent
two,
numbers 1, 2,
Only one,
3, 3 also?
3 petition, my lord.
Okay,
four,
okay.
three,
1,
four,
2, 5 also,
Yes,
5, 6,
6 I am appearing, my lord. Home, my lord. Home it will be under us.
okay, 5 and 6. 5 also,
5 also, I appear for 1, 2 and 6.
1, 2 and 5?
Superintendent of police, yes, madam, 5 and 6. 1 to
5 and 6. Ms. N. Chaudhary appears on behalf of the respondent number 3 and 4. Extra copies of the writ petition be served upon the respective councils by day.
My
As regards the respondent number 7, petitioner is directed to take steps by way of speed post. In addition to that, liberty given to the petitioner to effect service, speed post within 2 days. Liberty given to the petitioner to effect service upon the respondent number 7 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that in pursuance to a notice inviting tender dated 5/12/2025 issued by the respondent number 3.
Right.
The petitioner submitted the online bid in respect to the work pertaining to improvement and upgradation of road from Tamulpur Goreshwar Chowk to Goreshwar College from chainage 0.00 km bracket Tamulpur Goreshwar Chowk bracket close to chainage 7.630 km bracket Goreshwar College bracket close under Assam Mala 3.0 for the year 2025-26. The petitioner, upon submission of the bid in the online mode, went to submit the
hard
bid, the hard copy of the bid as was required in terms with the tender conditions. However, the respondent number 7 along with his accomplices stopped the petitioner from submitting the hard copy. It is the further case of the petitioner that the petitioner submitted an FIR on the same day before the officer in charge of Pokraja Police Station, as well as also to the SP Kokrajhar. However, no action in that regard was taken. It is the further case of the petitioner, therefore, that as the petitioner was stopped by the respondent number 7 to participate in the said tender by submitting the hard copy, the petitioner have assailed the notice to proceed with the work issued in favor of the respondent number 7 on the ground that the respondent number 7, the entire tender process was rigged by the respondent number 7. Considering the above, this court, the learned counsel appearing on behalf of the petitioner, submits that certain interim directions are required to be passed. In the opinion of this court, as the petitioner has approached at a very late stage, that is, after the incident, after 6 or 5 months from the date of the incident, this court is not inclined to pass any interim order today without giving the respondents an opportunity to submit their, place their side, place instructions. However, on the next day, this court shall consider upon instructions being placed. This court also finds it very relevant to take note of that the entire basis of the allegations made by the petitioner is dependent upon a report to be submitted by the respondent number 5 and 6 to the effect as to whether the petitioner had submitted an FIR as alleged in the instant proceeding, and if so, and if such FIR was filed, what actions were taken. The respondent number 5 is specifically directed to submit a report to that aforesaid effect on the next date. To list the matter accordingly. On the next date, this court, depending upon the report so submitted, shall consider as to whether there is a necessity of passing any interim.
And top of that, my lord, the issue is of December 2025. Now, my lord, in May here that close. You ought to have, my lord.
That is why, didn't I say that? After 5 months here,
5
they
months,
approach, so therefore I am not passing interim direction without giving you an opportunity. In clear, unequivocal language, I say. Mr. Gogoi, you must be actually thinking about some other matters in some other courts. Yes, Mr. Sigdar.
My lord, here in this case, my lord, the petitioner has purchased a commercial vehicle pass.
Huh?
He purchased a vehicle, my lord, commercial vehicle. And the original purchaser was one Toinuddin, financed by Tata Motors. Toinuddin failed to pay the installment, and on default, the Tata Motors taken the vehicle in his possession. Thereafter, Tata Motors sold the vehicle to me, and I got all documents, the RC, the pollution control certificates, everything I have got, and I am paying the road tax. Now, my lord, when I approach the DTO for grant me a special permission, special permission means my vehicle is to run from Gauhati to Golpara. So for special permission, it is required when we the vehicle is to move for other area.
What vehicle?
Means I may be go to other district for a to carry a marriage party. Then special permission is required.
Okay. So you have a permit,
Yes, a special permit.
special permit.
I have the RC.
You have
Then
the-
when I approach,
Are you using it as a commercial vehicle?
yes, my vehicle is a commercial vehicle.
So when you have a commercial vehicle, you must be using having a permit, I suppose.
Yes, yes. If we run beyond the route, I have, I required a special
Okay,
permission.
then
Then, when I approach the DTO for special permission, the DTO has said, DTO has informed me that my RC is locked. Whatever RC already given to me, that is locked. And Lordship may kindly have a look at the annexer at page 36. This is the documents. This is in the portal of the Bahan, and also they have given me information.
locked by Kamrup due to region, the letter number so and so. Yeah,
Then, my lord, ultimately because of this decision, my lord, my vehicle cannot operate now in my route which has been allotted, my lord. This is the RC has been given to me with due verification.
the bus.
Yes, bus, my lord.
Okay.
So my vehicle is now unusable, my lord. I am
Why locked?
Lordship, I have received a letter, it mentioned in the page 36, the letter issued by the ASPC. And the vehicle is reflected in serial number 72, my lord.
Uberization.
The scheme, Lordship, is a public-private partnership scheme under ASTC, where ASTC given the, it takes initiative to given the unemployed youth for their employment generation, the buses for which is running by the ASTC banner.
So his bus is running.
Buses now, I'm not sure.
no more.
Originally, it was under Uberization scheme.
Then
There have to some terms and conditions, they will have to deposit.
process any transfer of registration certificate of vehicles operating under alia.
Yes.
Did you purchase it new vehicle or old vehicle?
My lord, my
Old vehicle.
old vehicle, my lord.
So you purchased it from
From
somebody?
Tata Motors Finance, my lord.
Huh?
Tata Motors Finance.
Who? Auction.
My lord, auction, my lord. It was a pro auction sale.
So, and then you got your name registered.
Yes, my lord. I got the RC, I got the ARB documents, my lord. I am paying the tax.
Now, if the registration has been granted, when did you get the registration?
We got the registration is 13 May 2021.
13
Huh?
May
Registration date.
2021, if he has got the registration.
Initial
Well,
owner. I
initial,
think.
yes, yes. My
First owner left.
Now, when did you get your name registered?
my lord, my registration.
31st May 2021? No.
No, no, that is not the, my lord, my registration at page. Yes, my lord, page 31.
When?
It is 9 December 24, my lord.
So 9 December 2024,
Yes, my lord. In page 30 also in the down below. In the original card is also at page 31.
and December. How do you get it?
Yes. For their lordship may kindly have a look, rule 57 of CMGR.
We'll look into it. How we get the date?
Date.
Yes, my lord.
How do
My
we
lord,
get?
in the original card is at page 31.
Then?
My lord, in the
No, where do we get the date?
right, extreme right line.
Where?
Card
Okay,
issue
okay,
date, my
okay,
lord.
okay. Card issue date 9th of December 2024.
Yes,
Not 21,
Yes,
24.
24.
24, okay. So then the registration has been changed.
Yes, my lord.
Transfer has already affected. Now, on the basis of this letter, can you lock it?
Lordship, I will have to take instruction, lordship, but lordship may kindly have a look, rule 57 of CMGR 1989.
Yes.
That's
Rule
because the
57.
petitioner has purchased the vehicle through auction process, my lord,
Huh?
through auction process.
57. Okay. Transfer of ownership of vehicle purchased in public auction.
Lordship, then 58 no objection certificate. Then in the case of the transport vehicle, in addition to the last Lordship, subsection 58 2 Lordship. Documents referred to the sub-rule 1, documentary evidence in respect of the following matters shall also be furnished, namely that the vehicle is not covered by any permit issued by any transport authority, that the sum of money agreed upon be paid by the holder of the permit under the subsection 5 and 6 of section 86, if any is not pending recovery. Lordship, they will have to give all the information to the registering authority.
Understood, but the fact remains,
Yes.
can you, how do you lock this?
Because some amount yet to be recovered to the.
Did you
from the
intimate
petitioner.
him? Any amount is
He is
recovered?
not the original owner, Lordship.
No, fact remains that you know it. That is why you have registered
This
it
is
on
the
9/12/2024.
No, Lordship.
Yes, the card was issued in his name on 9/12/2024.
He is also
So
not aware.
therefore, and kindly see page 36, his name appears with all asterisk marks.
Yes, madam.
So
Understand, madam.
therefore, you know it, who is the owner. Have you intimated him? But what is this business of locking it?
Not to use. Lordship, I will get instruction, but ACC may be directed to take instruction, whether they have directed us to lock the vehicle.
There's no power of locking down. How do you lock down a registration?
Well, he is not the original owner. The original owner is under our Uberation scheme. He has purchased the vehicle from the Tata Motors under auction process. He's the third owner, I think.
My lord,
Second or third.
second. My lord,
Whatever may be,
Yes.
Tata Motors, you have a business with, you control the Tata Motors or the Tata Financials, that is your lookout. Tata Motors, by way of an auction sale, which is otherwise permitted under law to do so, have sold this vehicle to him. And he has purchased it without any encumbrance. There was a permit out there, and he got this permit extended at page 35, page 32. 33. Not 33. Yeah. Permit for contract permit. This is being given in his name. Can you
Yes,
see
Lordship.
page 32? That's
Actually, he is not the defaulter. The first owner might have something due with the ASTC.
for that, how can you do that
Yes.
locking business?
Yes, Lordship, I understand. but-
This type of action is high-handed.
Yes.
Compensation has to be paid.
Right.
You are asking how much? 16,50,000 as compensation?
my lord, my vehicle value is, we earn 5 lakhs, my lord, compensation. My
Aye.
bill, 5 lakhs, my lord.
And you want the vehicle or not?
My lord, we want the vehicle.
As well as 5 lakhs.
My lord, no, my vehicle value is 16 lakhs.
Then why do you need 5 lakhs?
My lord, as a compensation, my lord, only
Oh.
compensation.
Lordship, I will get instruction and file affidavit after the my lord may.
In the meantime, you remove this locking business. This is without any sanction of law. You remove this.
The Lordship may grant us liberty to proceed against the first owner, Lordship.
You do whatever you feel like. That is by law. But what is this locking? How do you lock lock means, how do you lock it?
The blacklisting of vehicle, Lordship. You cannot move the vehicle. You can use the vehicle. His
And you
RC has
did
been
it when?
blacklisted.
When did you do it?
Lord, it was 1st August 2025. Nice, Lord.
1st August 2020. No. It is dated 10/10/2025. Not that.
As per the letter of the ACC, Lordship has been locked. ACC have to take a call, Lordship. Why they have issued that letter to us? What is the liabilities from the first owner, Lordship? They'll have to clarify.
And where is the name of the petitioner bank?
72, Lordship.
Huh?
It's 72. The number is here, but original owner was different, Lordship.
Ainuddin Ahmed.
Yes, Lordship. A01NC2135. I have stated in the writ petition. This is the vehicle number, but original owner was different,
So take it up with the Tata Motors.
Lordship.
This has nothing to do. No, issue notice making it returnable on. Why are you making everybody a party?
My lord, yes, my lord. Yes,
You notice making it
six is not
returnable
required.
on
Just in six is
24th
not
of June, 2026.
Lordship. In this case, we have not served copy, ACC. Our name is also not reflected in the Cosmos Lordship, and we
You
not
have a standing council.
Lordship, ACC.
Fantastic. You are saved from the trouble. She noticed making it returnable on 22nd of August, June 2026. Ms. MD Bora accepts notice on behalf of the respondent number 1, 2. Ms. So-and-so, who is the standing counsel of the ASTC, accepts notice on behalf of the respondent number 3. Extra copies of the requisition be furnished to them by tomorrow. As regards the respondent number 4, 5, and 6, petitioner is directed to take steps by speed post by 2 days, by Monday. It is further observed that this court further directs the petitioner also to effect service upon the respondent number 4, 5, and 6 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the action on the part of the respondent number 1 and 2 in locking the registration of the petitioner's vehicle bearing registration number AS01NC2135. Full stop. Mr. A.R. Sikdar, the learned counsel appearing on behalf of the petitioner, submits that the petitioner had purchased the vehicle through an auction purchase from the respondent number 4 and 5, isn't it?
Yes. Tata.
Well, from the respondent number 4 and 5. And thereupon, the vehicle in question was registered in the name of the petitioner as far back as on 9/12/2024. The permit in respect to the said vehicle was also issued by the Secretary State Transport Authority on 10th of June 2025. When the petitioner took the said vehicle, when the petitioner, the learned counsel submits that the permit, which were the permit of the petitioner's vehicle was only within the Gwalpara district.
Gwalpara to Gauhati.
Region covers is inter-district permit. Was from Gwalpara to
Gwalpara.
Gwalpara, inter-district. It is inter-district transfer permit.
Gauhati to.
Huh?
Yes. Inter-district.
And the permit which was available was an inter.
Gwalpara,
No, no.
and Nolbari border.
Where is your earlier permit?
My lord, you will find this, my lord, annexer 4 at page 32. Purpose of journey.
That I understand. I'm not on that. This is where you went out there. Not on that. You say that your vehicle was within a particular district. You had to run in a particular permitted area. Which area?
My lord,
From
from
Gauhati to
Gauhati,
Agra via Nalbari.
No, that is only for that day.
my lord, that is the road he is to run.
You run.
Yes. my lord.
It is the case of the petitioner that the petitioner vehicle was permitted to run to carry passengers from Gauhati to Gwalpara via Nalbari, Borpeta Road, Bongaigaon and back.
It's valid till 2028.
Hmm?
It's valid till June 2028, 9 June.
The petitioner sought for permission for moving the vehicle to a separate route for a special purpose. The petitioner was shocked to learn that the petitioner's vehicle's registration number was locked. The petitioner further submitted representations to the respondent number
My lord,
5 and 6,
my lord.
isn't it?
5 and 6.
5 and 6.
5, 4 and 5.
To respondent numbers, no, respondent number 2. Respondent number 2, 4 and 5.
4 and 5.
However, as no action was taken, the petitioner has approached this court by filing the writ petition. Ms. M.D. Bora submits, the learned counsel appearing on behalf of the respondent number 1 and 2 submits that steps have been taken against the petitioner's vehicle on account of a communication issued by the Managing Director ASTC dated 22/7/2025, wherein the vehicle of the petitioner was earlier operating under the Uberization scheme of the government of Assam. And therefore, as there was no financial clearance was provided by various vehicles, provided to various vehicles by the ASTC, including the vehicle of the petitioner. The petitioner's vehicle was, registration of the petitioner's vehicle was locked. In that regard, the learned counsel had placed the communication dated 22/7/2025, which is kept on record and marked with the letter X. It may not be out of place at this stage to take note of that the petitioner's vehicle was registered in the name of the petitioner as far back as on 9/12/2024. And therefore, the said communication dated 22/7/2025 would not have been made applicable to other petitioners, inasmuch as the said communication only related to not to transfer the registration certificate, which already in the case of the petitioners to transfer it as far back as on 9/12/2024. In addition to that, this court also finds it very relevant to take note of that the petitioner herein have purchased the vehicle from in public auction from the respondent number 4 and 5. And therefore, the said purchase so made was, and as claimed by the petitioner, it was without any encumbrance. Consequently, therefore, in addition to that, nothing could be shown on what basis the registration could be locked, more particularly at the instance a request made by the respondent number 3. Under such circumstances, this court directs the respondents, more particularly the respondent number 1, 2, and 3, to bring on record their stand by filing the affidavits on or before 17th of June 2026. In the meantime, the respondents shall reconsider as to whether the vehicle of the petitioner should be, the registration of the vehicle of the petitioner should be kept locked should continue with by keeping the vehicle of the petitioner under the registration of the vehicle of the petitioner locked. And specifically keeping in mind that the petitioner, that keeping in mind that an unauthorized action to lock the petitioner's registration, if found, may result in imposition of damages.
Pendency may not be about to do the needful. Pendency may not be about to do the needful.
Pendency of the, it is also observed that pendency of the petition, pendency of the petition shall not be a bar to remove the lock over the registration of the petition.
So for the petitioner case is concerned. So far as the petitioner case is concerned. Also.
Petitioner only.
No,
Do you want the name of the petitioner to be put moving off?
there are some other vehicles also listed. Deeply obvious manner.
Of the senior administrative assistant advertisement. Under the labor code Gauhati, the advertisement page 22. Page 22. Name of post senior administrative assistant UDA, one post unreserved and grad. The
Phone number?
On page 22.
Yes.
Senior administrative assistant UDA, one post unreserved, graduate in any discipline is the qualification, and candidate serving as junior administrative assistant having not less than 5 years of continuous service as of so and so date. Now, your lordship would kindly note that this is a post advertised for UDA. The qualifications are of junior administrative assistant, and the pay scale, your lordship would kindly note the pay scale, that is pay band 2, 14,000 to 70,000 and grade pay of 8,000. Now, there's an addendum which was given at page 24. The addendum said at page 24. The addendum said that again, with reference to notification so and so, against which applications were invited for recruitment to the post of senior administrative assistant UDA, it is hereby notified for the position mentioned above, all concerned persons equivalent to the pay scale as mentioned in the above mentioned advertisement of this establishment, irrespective of their designations, are eligible to apply. Now, coming back to the advertisement, my lord, they said that equivalent pay scale, similar designations. Now, coming back to the advertisement, this can mean two things, my lord. Either the pay scale of junior administrative assistant, that is the qualification, or that is of UDA. Senior administrative assistant, then the pay scale of senior administrative assistant is already given. Now, the selection procedure was carried out and the result was declared on 6th of May at page 30. All of the petitioners participated, my lord. Petitioners 2 and 4 are of UDA rank and 1 and 3 are of junior administrative assistant rank, my lord. Now, the result is at page 30.
With the response number 5 is what?
5 is a system analyst, my lord. He is a system analyst under the session judge Gauhati, Kamrup Metro. He also participated, my lord, and he was selected at page 30, my lord. This is the result. Now, if I may take your lordship to the notification given by the finance department at page 33. This is to point out the pay scale. At page 33, this is a notification by the finance department after the revision of pay. And at page 34, the lordship will note at page 34, serial number 14 is UDA. Pay band 2, 14,000 to 70,000. grade pay of 8,000. That is what is reflected in the advertisement. Now coming down, my lord, from serial number 18 to 24, I come within this. Lower division assistant at serial number 21 has now been redesignated as junior administrative assistant.
Now, there is another notification giving equivalence. Where is that?
But there is no equivalence.
Ah, there is.
Junior administrative assistant.
No,
with
there
equivalence.
is. Where is that notification?
But I have not have that. I do
Hmm?
not have that. I do not have-
Mr. Bharadwaj.
But
you-
my case is.
No, nothing doing. You,
Well,
where is that
So
notification?
if that notification says that my lord, the system assistant is in par with UDA, then I don't have a case, my lord. But here the system
System analyst is not a system.
assistant, my lord, that
Assistant is not at par with the UDA, but whether it is at par with JA. See, there is a notification issued by the governor of Assam as regards the, what you call, the equivalence. Where is that? And where is the Guwahati High Court Council?
this is a
They have
labor
not made the
code.
Guwahati High Court a party.
No, this is labor code. This comes under the labor department.
Huh?
The advertisement is by the labor
No,
code. man.
Mr. Council, these are all being done by, under the Guwahati High Court.
But this comes under the labor department, man.
There cannot be anybody appointed. These are all under the Guwahati High
The
Court.
participants are employees of Guwahati High Court, my lord, but the advertisement was by the labor code, man. That's why I have not added. I had
You
written
have
it,
to
man.
make the Guwahati High Court a party. They would have come up with it because you see, these are all being done under the central recruitment things. And these are, and if you see one judgment of the Supreme Court wherein it says that all, now these people are all getting, you know, all these people are getting the SETI commission. The reason why they are getting the SETI commission because they are held to be persons coming within the subordinate judiciary of the Guwahati High Court.
Now, in that case, my lord, if system assistant comes at par with junior administrative assistant, my lord, and with the same pay scale, then I don't have a case. Because that.
Why have you enclosed this document? 1987 rules.
My lord, this is for mentioning the category.
Decided that matter particular MSP's tribunal case, the equivalence matter was just decided.
I'm not there. I'm delivering the judgment on Monday.
Yes, Mr. Council,
That is for the purpose of register.
lost that part. Otherwise, here also he is.
In fact, all these people come, they are getting this scale only on because of the SETI commission.
Lost.
You have to make the Guwahati High Court a party.
For airing them and then praying for an interim direction, my lord, it will take some time. If I may withdraw it and refile it on Monday, my lord, and make a mention. Because to file an IA and then getting them impleted and then praying for an interim direction, that will take some time.
You like to withdraw with the liberty.
Well, on Monday, I'll air them as
How
party.
do I know you are going to file it on Monday? Is your person waiting just right outside in the corner?
I'll call them in the weekend.
Eh? You are working as what?
My lord, the petitioners 1 and 3 are junior administrative assistants under the district judiciary Kamrup Metro. And 2 and 4 are UDA.
So they are all JA.
I have stated it.
They have an equivalence notification. You have a look at.
I'll do so.
So that is why this corrigendum was issued. Because the corrigendum had to be issued because otherwise what will happen? This is another big problem which was faced in another set of cases here. For the post of administrative officer, you need to have become somebody. And there was a problem that, oh no, that was not administrative officer. Yes, administrative officer, you need to become, there was a, Mr. Sharma, Kanak Sharma. You remember one matter where there was a problem where I passed an order to the effect that although very sad I was in passing the order, but I didn't allow your repetition to, there were two repetitions taken up together. No, not market settlement. As regards a promotion to a particular post, whereby your officer for whom you were representing, they were appointed they should have been appointed as LDA, but they were not appointed as an LDA, but they were appointed in some other capacity. And they continued for a long time. They wanted to get promoted to the UDA. I said that you could not have been promoted unless that post was brought within the fold of the 1987 rules. And that is the reason why, remember?
In my case.
One case.
Oh, yes, it is pending, madam.
So that is
Because
what.
there are two other cases of the same. Here, your lordship has allowed, has not passed any order in another case. That is also readable and myself, another case from Udalguri.
Udalguri. That was the case from Udalguri and Baksa.
Oh, yes.
You see, these three places, they were accountant, I remember now. Now, whether an accountant can be treated to be an UDA for the purpose of promotion to the post of administrative officer, that was the case. Now, this accountant have not been brought within the fold of year. And now, in these draft rules, accountant has been brought in. Because it is only in those three districts of Udalguri, Sirang, and
Udalguri, Sirang,
Baksa. These are the places there were 6 posts of accountants which were there.
No, these three cases are taken together. It is pictured 12-6, my lord.
Anyway, but that is the issue. So therefore, the problem is you have to withdraw, make the Guwahati High Court a party, because these are actually done. I am surprised. These have to be done under the aegis of the Guwahati High Court. You just wait for some time. Kindly call Mr. H.K. Das.
I'll do so.
We'll have a look.
We are directed to take updated instructions.
What happened?
Certain instructions were sought from the district commissioner of Sirang, which is PTDA. So that has been waited. Some time will be required.
You want to create a record of a contempt petition being pending for such a long time?
During the district of.
It's a contempt petition of 2016. Does it look nice?
During the
If you are not being able to carry out the verification, every time the matter comes up, you on earlier occasions, it was mentioned before this court when I was taking it up that you have set up a cabinet subcommittee. That is in the year 2025. We are in the year 2026. Every time it keeps on changing every day. So you have set out a cabinet subcommittee. What is the report of the cabinet subcommittee?
They are ready to pay, but certain information are required.
From the DC.
District.
And the DC, when did you write the letter to the DC?
As per the instruction last yesterday we have written. Earlier also we have written now.
Hey, you write to a letter immediate 1 day before the matter reaches.
Earlier also we have done nothing.
And why is the DC not helping you out?
Maybe the election or any other problem. But
Election is over. Then
we have written on 7/1/2026. Yes, yes, but last instruction also. We have submitted before this.
no, Mr. Dotto, why I'm saying is there's a cabinet subcommittee appointed to make the verification. This verification was being carried out. So therefore, I'm asking you, what is now the role of the DC? If you have carried out the AR of this by the cabinet subcommittee. Where is Mr. Arbor Pujari?
Due to some personal they left the court. Due to some personal difficulty, they left the court. That's now we have taken. Is it?
Both the contempt applications have been pending for long. One contempt application is almost a decade old. Is a decade old, whereas the other is nearing a decade. Every time the matters are listed before this court, the Revenue Department apprises this court that further more time is required for compliance with the orders passed by, for compliance to the judgment and order. For affecting compliance. On the ground that there is a requirement of identification amongst 37,603 families who would be entitled to compensation on account of the ethnic violence during the year 1996 and 1998. Of 37,603 and 6,581. These families have suffered and had suffered 30 almost 30 years ago, and are yet to receive their entitlement as per what the government declared. Under such circumstances, today also, the Undersecretary to the Government of Assam, Revenue and Disaster Management Department has placed an instruction, had given an instruction to the Standing Council of the Revenue and Disaster Management Department, dated 14/5/2026, that certain communications have been issued to the District Commissioner Srirang for providing further inputs. It is a sorry state of affairs. Whereby the state who are required to provide the necessary assistance to those persons who have been affected on account of the ethnic violence in the year 1996 and 1998, on account of carrying out verifications and verifications, have not been able to provide the benefits. Under such circumstances, this court grants a final opportunity to the respondents to carry out the necessary verification and disburse the amounts within a specific period of time, failing which this court may be constrained to initiate appropriate proceedings for violation of the orders passed by this court. List this matter again on 28 September 2026. This can't go on like this, Mr. Bond. Both of you want to create a record in that I appear in a contempt matter which is 10 years old. Huh? Is it something like that? Tell me.
Yes.
And if you have no control, you had earlier a subcommittee to verify. In the subcommittee, didn't you think that the necessity of having the district commissioner a party? You did not. And every time, can it go on? It's a case where these people from 1996 who have suffered are asking. You say that, okay, they don't get it. It's a different aspect. But you don't do that. You're just delaying and delaying and delaying and delaying. A person who has been affected in the year 1996, 30 years have gone. Sorry, state of affairs. Mr. Soliha.
These are two batch of contempt petition, Lordship, which were filed in the year 2019, Lordship. Now, Lordship had directed me to assist the court because it was to be paid by the health department, Lordship. Now here, Lordship, I have spoken with the current incumbent. Lordship, some documents of verification is needed, Lordship, because they do not have the record. These are 2019 payment orders, Lordship. The current incumbent is only requesting if the petitioners can just cooperate and just visit him once, Lordship. And he,
Okay.
some
When do you want the petitioner should visit you?
Lordship, any date. Lordship, I have been informed any date they can inform me.
You go and visit.
Some
Mr. A. Solia, the learned counsel appearing on behalf of the health department submits that on account of there being no proper materials available, the order dated 13/2/2019 passed in WPC number 5 available, necessary verification could not be carried out. And under such circumstances, the order dated 13/2/2019 passed in WPC number 5886/2017 could not be complied with. Yeah, he suggested that if the petitioner appears before
the Director of Health Service, FW. Director of Health Services, FW, Family Welfare.
That if the petitioner appears before the direct office of the before the Director, Health Service, Family Welfare, Health Service and Family Welfare, or
bracket FW.
FW, the process for verification could be carried out on an urgent basis. Under such circumstances, the petitioner herein is directed to appear before the Director of Health Service? When?
Lordship, any date, Lordship.
No,
as per the-
no, we fix a date. Otherwise, this petitioner who is asking for 2,70,000, he may spend all his money only
Lordship on Monday.
moving
Lordship.
from one place to the other.
Monday, this Monday. Lordship.
Monday not possible, no? Where is the petitioner? He is from Dhing,
Lordship,
Nagaon.
Lordship, Wednesday. Lordship can fix the date. Lordship will pop.
We'll have it, shall visit the office of the director of, shall visit the Director of Health Service on 22nd, you can do? Huh? On 22nd of May 2026, along with the necessary documents available with the petitioner. And the Director of Health Service, bracket FW, shall then proceed with the necessary verification as regards the petitioner's entitlement. An update be placed before this court on 15th of June 2026 by the response.
Next item.
Similar item. Lordship.
Similar item,
The two
11
items,
item.
two.
Same. Khali number 2 side over there.
This case, Lordship, the affidavit has been filed by the respondent. There are 6, page 19. They have stated that due to oversight, the petitioner's case was not audited, Lordship.
Huh?
Due to oversight, the petitioner's case was not audited. In para 6, page 19, they refer.
Now a new person is there.
Yes.
Mukesh Sahu, making a party. Mr. Ardhar, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an appropriate application for including the present incumbent principal secretary BTC as a party to the instant proceedings. List this matter upon such application being filed.
13 also same, Lordship.
Huh?
13 also same.
Same, na? 13 same. So many contempts. Oh, you are appearing.
Lordship, I think 13, item number 13, we have paid, as per instruction. It says paid,
13 to be up. Same no. And 12, Miss, Madam, you do one thing, 12 appear and find out why haven't you paid till now. There is an affidavit filed by your earlier predecessor, not you, that, yeah, they have filed it. 13 you have paid. Miss N. Chaudhary, the learned standing counsel of the BPC, submits that the petitioner have already been paid the amount of rupees 21,92,000. And in that regard, have submitted, placed before this court, the instruction issued by the Secretary BTC Kokraja dated 13/5/2026, which is kept on record and marked with the letter X. Taking into account the above, this court therefore closes the instant petition. In as much as the said is insufficient compliance to the order dated 17/12/2021 passed in WPC number 6482/2021. Isn't it? 6482. ठीक है. X করা আছে না? 15 কি হবে? Oh. Mr. Keshav, yes, what is this?
In this case, I am speaking what has been passed. Meaning thereby loss saying thereby that there is no work order and the work
stated to be has been completed by him, it has been done by another.
Work was done by this contractor order here, but ultimately payment was made to another contractor.
The present application heard Mr. K. Sharma, the learned counsel, appearing on behalf of the petitioner, Mr. N. Upadhyay, the learned standing counsel, Irrigation Department, appears on behalf of the contemners. This is an application. Alleging willful and deliberate violation to the order dated 10/2/2023, passed in WPC number 241/2021, whereby the learned coordinate bench of this court directed that the claim of the petitioner be verified and paid in terms with the full bench judgment of this court in the case of Kamser Ali and others versus State of Assam and others, reported in 2008 4 GLT 1. On account of no payment being made, the petitioner had approached this court by filing the present application. Mr. N. Upadhyay, the learned standing counsel of the Irrigation Department, pursuant to the order passed by this court on 11/5/2026, have placed before this court a speaking order dated 8/12/2023, wherein it was mentioned that the claim of the petitioner was unjustified inasmuch as the work was completed by one Babul Nath and the said Babul Nath have been paid his dues as per the works were done. In that regard, he has placed before this court the instruction dated 21/12/2023 of the Chief Engineer Irrigation, which is accompanied by the speaking order dated 8/12/2023, which is kept, and both are kept collectively on record and marked with the letter X. Taking into account the speaking order dated 8/12/2023, nothing further survives in the instant contempt application, for which the contempt application stands closed. Before parting with the record, this court, however, observes that if the petitioner is aggrieved by the speaking order dated 8/12/2023, the petitioner would have the liberty to approach the appropriate forum, if so advised. Complied, no? Mr. B. Chaudhary, the learned counsel, appearing on behalf of the contemner, submits that the order has been duly complied with. Order dated 9/11/2023, isn't it?
Yes, ma'am.
Passed in WPC number 2912/2014, have been duly complied with. In that regard, he has placed the release order dated 31/7/2025, which is kept on record and marked with the letter X. Under such circumstances, the present contempt application stands closed. Mr.
Lordship, we have filed an affidavit, Lordship, may I serve a copy of the Lordship?
What did your affidavit say?
It says that we are disputing the, because there are some discrepancies now. So if I. At page 19, your Lordship.
What is the direction? Let us see.
At page 11. Paragraph number 7. Verify the claim of petition, reduce the pending bill. If so,
Verify and pay.
verify and pay. After verifying this discrepancy, we have found, Your Lordship, page 19.
With reference to your letter, it may be mentioned that the fund demand has been scrutinized on the basis of the memorandum. And the following is, the documents have not been countersigned by signature and seal of the memorandum. The date of accuracy has been mentioned is not traceable. We requested to furnish clear justification about the countersign. Demand is returned. Now, what is your verification?
Verification here, the issue is that since verification could not be completely carried out because of all these reasons, Your Lordship, and
Huh?
because of these 5 reasons stated in this page 19, verification completely cannot be carried out, Your Lordship.
Okay.
And this work order seems like it's a work order way back in most probably in 2000. Old work order, Your Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. R.R. Gogoi appears on behalf of the PhD department.
PhD department.
Full stop. The present application has been filed alleging willful and deliberate violation to the order passed by the learned coordinate bench dated 28/10/2024, passed in WPC number 2206/2022. From a perusal of the order dated 28/10/2024, it is seen that the learned coordinate bench of this court have directed the respondent authorities to verify the claim of the petitioners and release the pending billed amount, if so entitled in accordance with law, within a period of 3 months from the date the certified copy of the order is served. It is seen that in pursuance thereto, an exercise was carried out for release of, for making verification. While carrying out the said verification exercise, it was found that there were various deficiencies in the documents. And as such, the demand proposal was returned. The deficiencies have been mentioned at Annexure A to the affidavit so filed by the respondent number 1. Considering that the verification cannot be carried out on account of those deficiencies, it is the opinion of this court that the present contempt application would not lie, inasmuch as there cannot be said to be a willful and deliberate violation to the order dated 28/10/2024, passed in WPC number 2206/2022. In that view of the matter, the present contempt application stands closed. Liberty, however, is given to the petitioner to avail other remedies if so advised as per law.
My lord, in the page 19, they have not mentioned the documents or they have not annexed the document.
You see, the thing is, when can it be a willful and deliberate? When they can and they have not. But when they cannot, that is what they say. These are not there. So therefore, you are giving the liberty.
Public.
Yes,
Non-payment of contextual payment. Non-payment of contextual payment.
you are not taking steps. Why should we be non-payment of contractual dues? You have not taken no steps for issuance of notice taken upon respondent number 1 and 2. Who is responsible?
For 1 and
Then why should we? Well, there are only 2 persons and you have not taken steps. And you are appearing. Don't
Copy
appear.
has been served to us, Your Lordship.
You wanted an adjournment in the morning, no?
Yes, Your Lordship.
Don't appear. Let me pass an order directing them to take fresh steps.
My lord, we have already served copy to her.
Okay, now what do you want?
Lordship, adjournment for today, Your Lordship, as affidavit has been awaited, Your Lordship, on next week, Your Lordship.
Ms. So-and-so appears on behalf of the respondent number 1 and 2 and submits that the said respondents would like to carry out necessary verification and apprise this court as to whether the petitioner is entitled to the amount as claimed. Considering the above, list this matter again on 3rd of August 2026. In the meantime, the respondent number 1 and 2 shall verify as to the entitlement of the petitioner and thereupon submit a report by way of an affidavit on or before 29th of July 2026. It is further observed that pending the next date, it shall not be a bar on the part of the respondent authorities to disburse the money if upon verification it is found that the petitioner is entitled to the amount. List the matter for admission.
What you will find the order dated 27 to
Item 20.
20.
Counter affidavit has been filed and received by the respondent. Who is the respondent? Forest
Counter not filed.
and BTC. Why you are not filing it?
Instruction is awaited, Lordship.
New matter, na?
Yes.
Only thing is that my
You are enjoying an interim order.
yes, my lord.
Okay, we made the interim order absolute. What do you say?
No, Lordship, as the excluded question is the e-tender, Lordship. E-tender process adopted by the BTC authority recently. And regarding this, Lordship, we want instruction and praise for some time.
There is no urgency on your part. You have urgency or not?
So we have
You
urgency,
don't have.
and there is respondent number 7, private party is also there, respondent number 9.
So you have no urgency. Service is complete.
My lord, that's this, my lord, problem, my lord, because the order dated 27 to 26, paragraph 9, my lord. It has been recorded that petitioner takes steps for service of notice upon respondent number 2. And the office note dated, my lord, 25 to 26, my lord. Though we have taken steps for respondent number 9, my lord. But since in the order it has been reflected that respondent number 2, my lord. So notice could not be, my lord, so office note dated
My notice has not been issued to respond number 9.
20, office note dated, my lord, 25 to 26, my lord. Because in the order dated at paragraph 9, my lord, it has been reflected that respondent number 2. In the order dated 27.
Should there be respond number 9?
My
Yeah. The record reveals that service upon the respond number 9 is yet to be completed. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to effect service upon the respondent number 9 by way of trustee. You want or not? Okay, we in time order we do not continue.
yes, my lord.
Yes. That means that he would like to take steps by way of trustee upon the respondent number 9. Taking into account the above, list this matter on 19th of June 2026. Service by way of trustee be effected upon the respondent number 9 by the petitioner on or before 3rd of June 2026, and an affidavit be filed to that effect. Affidavit of service be filed to that effect. It is also observed that the service by way of trustee should be routed through the registry of this court. Ms. N. Chaudhary appears on behalf of the respondent authorities, respondent number 2, 3, 4, 5, and 7. And Mr. K. Gogoi appears for the respondent number 6 and 8. Forest. Mr. R. R. Gogoi appears for the respondent number 1. The respective council submits that they would also bring on record their stand by filing the affidavits on or before 9th of June 2026. Liberty given to the petitioner to file reply thereagainst on or before the next date. Interim order passed earlier shall continue till the next date. Oh, yes. Mahakali Tea State. Yes, plus. What is this I business?
Lordship, that matter, Lordship, the clarification. Lordship, you passed an order in the WPC disposing it off, Lordship.
Huh?
Lordship, it's a Mahakali matter, Lordship. Earlier you passed an order on 13th.
Ah,
Regarding a simple Lordship clarification sought by the tribunal.
which order you are referring to?
Lordship, it passed on 13th, Lordship, in WPC 2476.
What did they pass?
Lordship, proceed the matter on the merits.
Aha, yes, yes.
That.
So that order you have got it or not?
No, Lordship, not till now.
We'll get it. But anyways, that you have nothing to say of this.
Lordship. It may
Or-
be before the
Or
appropriate
should
bench.
we clarify to the effect? We don't need to clarify.
Actually, Lordship, there is one more agreement. In case of Mahakali, Lordship, the agreement is 1/1/1990. That is what we are pressing upon, Lordship.
Now, if it is a case of correction, then it has to go before Justice Mehdi.
Lordship, that's what.
But you see, it is only the preliminary issue not be decided. It will be decided on merits.
Yes, Lordship.
Now, if it is decided on merits, the main, I don't understand why, with due respect to the court-led bench, why it was required, because the basic issue was there.
Lordship.
If I remember correctly, the first issue is as to whether the management of the tea state was justified in not granting the pensionary benefits in spite of there being an agreement. In spite of there being an agreement with the management. That is the issue.
That is the issue.
So if that is the main issue, why is the question of preliminary issue?
That's.
Isn't it?
Isn't it?
If it was a different issue, it would have been say, why do you have a preliminary issue that without going into the main merits,
No.
can the matter be disposed of? And with due respect again, in a labor court matter, preliminary issue is only decided in respect to fairness of the inquiry.
Lordship.
Because then you don't need to go further and for tendering evidence and other evidence. So therefore, at the time of fairness of the inquiry, what to do? Because
Lordship.
if tomorrow
Lordship.
the learned coordinate bench passes an order
Lordship.
and makes this correction,
Lordship.
wouldn't that go counter to which I have already passed down?
Lordship, that's. As per our Lordship, the case might proceed on merits. There is no issue in it, Lordship. Because this agreement dated 1969 one not has been pressed upon by any of the parties.
You see, what did you ask for? See, although you challenged the reference,
Yes.
but at the end of the day, the council who was appearing for both the Pagades submitted that look here, we are not going into the challenge today, but this be decided as a preliminary issue as to whether there is a bar under section 18. Isn't that the case? So if that be so, the court held that okay then, but isn't that the main issue?
Yes.
That's the main
That's
issue.
the main issue. It's applicable to section 18. That's the main issue.
Should we, I can close this saying that in view of that order passed in WPC number so and so. That is a better option.
That is a better option.
Urged Mr. S. Das, the learned
K.
counsel
Dasmurthy.
appearing on behalf of the petitioner. Good. The learned counsel appearing on behalf of the petitioner submitted that in view of the order passed in on, what is the date?
13 on 13 was.
On 13/5/2026
In WBC 2476.
in WPC number so and so,
26.
there would be no necessity seeking clarification to the order dated 19/9/2022 in WPC number 5586 of the 2021. Taking into account the above, the instant application stands closed.
How do I close? Praying for implement of the partner, respondent number, container number 3 and 4. The transfer.
This is an application filed for implement of the opposite party numbers 1 and 2 to the accompanying
3 and 4.
application.
3 and 4.
Whose- The reason for filing the instant application in as much as the earlier the contemners in the accompanying contempt application are no longer holding the post and the present incumbents, the present opposite parties are holding the post of the chief engineer and the executive engineer of the water resource department. Taking into account the above, this court completes the opposite party numbers, both the opposite parties herein as respondent number
3 and 4, my lord. Keeping the water resource.
What 3 and 4? It will be 5 and 6. 5 and 6,
Yes.
the accompanying contempt application. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days. And the registry shall, on the basis of the said memo of parties in the present order, make necessary changes in the cause title of the accompanying contempt application and update the same in the CIS. IS stands disposed. You are appearing for?
I appear for 2, 3 and 4.
Now you appear for 1 and 5 and 6. Huh? What is their notice? Let us see what is the case.
I can appear, your lord.
Appear. You see, this is only delaying it.
Already filed my.
What is the matter about?
It's a non-payment of contest or bill. That I have stated in my affidavit in
Oh, this judgment.
some amount has not been released by the Ministry of Jal Shakti.
Part payment has been made.
Also part.
Balance amount remains of rupees 18,76,000.
You have not been able to pay because of the day having not made.
Yes, your lordship. I have made specific statement in my affidavit, your lordship, that some amount has not been released. That's why maximum amount already he has got, your lordship. Only 18 lakh something in there.
I think in view of their stand in the affidavit, you see, there was a specific direction passed by the learned coordinate bench. Kindly come to page 166.
Yes, my lord.
Within 15 days from today, the concerned officials of the state government will communicate the supplementary budget passed in the last assembly pertaining to the scheme to the competent authority of the Ministry of Jal Shakti. Have you done this?
Yes, your lordship. We have already done that on.
Within 60 days of the receipt of such communication shall release the amount due under the scheme. Now, if they don't do this, wouldn't that amount to a violation? So are you therefore not required to make the Ministry of Jal Shakti a party?
He's a party, your lordship. In the contempt petition, ministry is already party, your lordship.
The party?
Yes, yes.
Then who is appearing for them?
That's for number one, your lordship.
Who is appearing for them? Anybody is appearing? Service is not complete. Union Council,
Name not one.
Mr. K. Gogoi. One thing good about Mr. K. Gogoi is he can appear for both the state and center whenever it is necessary. Can you inform her? Today she is there. Is she there? Call her after some time. We'll pass an order to the effect, asking her to inquire whether, what is the stand. Let us see how things are. Whether you keep on making party after party, it makes no sense. We'll have it after some time. It will do order to hold it, huh? Make it possible.
The challenge herein is to an award of the labor code. The issue involved is there was a settlement order in the labor code where a certain amount of claim was admitted by the company against a workman pursuant to a termination. Now that claim amount remained there. If the settlement was there, it was not paid. Subsequently, there was a Section 7 IBC proceedings. In that proceeding, ultimately,
Which order you are challenging?
I'm challenging the order at page 72, wherein the labor court has held that even if the said decree holder did not make a claim under Regulation 6 of the IBC proceedings during the resolution proportional activities, still because of his ignorance, he should be given the money. That was earlier settled with the company, based on which there was an award passed. That award is at page 24. That is the issue to be decided on. Facts are not disputed.
Who is paying for the other side?
Legally,
You are paying for?
legally as legally it comes. For that purpose.
Legally. Okay, this is an amount to be 1,80,000.
1,87,175. It's not about the amount.
What is your case? She is not entitled to.
Not entitled because we are the new company now. Pursuant to the IBC proceedings, a successful resolution applicant was ultimately found. And finally, the company, it was the successful.
Was this due taken into consideration in the IBC?
The
It
claimant,
should have been taken into consideration. This order was passed in 2021, first and foremost. Where is the IBC proposal wherein it says that this aspect was taken into consideration? You cannot, because first and, you see, in the order of the priorities, the workers have a very high order. Your case appears to be that once you have taken over this particular land.
we are a new company.
Yeah, pursuant to an IBC proceeding, you take it without anything. It's a clear
Clean slate.
It's a clean slate.
concept.
We have not. But whatever may be, there is a necessity to, you have to then move the NCLT.
Lordship, that
The-
he was not informed about.
No, the resolution professional had given a notification, public notification under Regulation 6 of the IBC, asking all the claimants, whoever there is claims, to submit their claims. They choose not to raise or submit their claims. Pursuant to that, the creditors, committee of creditors, finally had approved the resolution plan, and we were the new company who have now been given the company to run. As now we are Assam
Understood.
company, India level. It's a new
And-
company
He has a case,
under Section 31
strong case. He
because
has a very
That's right.
strong
I
case,
would like
but the
to point
problem
one
is
thing.
under Section 3,
all-
creditor is a decree holder also.
It is a
the mind, the mind of magistrate. He has a very good case.
Claim is not applicable upon us is what we are saying. Claim
Very
remains,
good-
but it's
he
not
has a very
applicable
good
upon
case.
us.
If the claim was prior to that,
Yes.
prior to the IBC
IPC
resolution
proceedings. That is undisputed.
is a very good case. But
So
what
far
to
as
do?
my lord, that the initial decrease.
We'll do one thing.
Lordship.
During the July month, let us think about it. And in the month of July, we take it up and finally dispose it of. In the meantime, if you can think something and I also can think something to wriggle you out, very good. Okay. Let us both try. You are also legal aid. I will also give you further legal aid. And then both of us let us fight to push the Asia because he has a very tight case, very good.
So our concern, honestly speaking, it should not be treated as a precedent later on because we do not know.
I understand.
Whoever
you
are
have a
or-
problem.
We do not know how many
I
documents
understand
are
the
there.
moment we open up,
Yes,
this
any
sort of this
application
will
will
have
come down.
far-reaching consequences.
We are
We
afraid of
cannot
that.
touch it.
We are
That
afraid
is
of
the
that.
problem. But only thing is,
There are multiple gardens, multiple
yes,
departments. We do not know.
this order has to be set aside because it will open up Pandora's box.
Yes, I can understand.
That is our fear, honestly speaking. Not the amount per se, but that fear.
Then also let us see.
But
What
I
to
would
be
like to
done?
point out one thing,
Huh?
my lord, that initial decree against that payment, my lord, it was settled in a consent order in low card judgment. There, the 30 days
With
period
the
was
earlier
there.
company, not with us. We are a new
Even
company.
maybe, my lord, that process of resolution has been taken after 1 year of that order, my. So by the time they ought to have been paid to the petitioner, my lord, but you are.
Not us, not us. My
Presently not
my
us,
predecessor,
previously.
me. The claim does not lie
No,
against me.
anyway,
That is my case.
Cannot lie against him.
That is my case.
Because if we
I am a
open
new
up
person.
this, people will stop doing anything. There were many cases which have been filed. I have dismissed many cases. And I'm also bound by my own orders. Anyways, taking into account that the records are available and it is a claim and there's a stay, na?
Yes, Lordship.
Lordship.
Because the direction to pay.
There's a stay.
Yes, Lordship. Because there is a direction to pay. The labor court has given us a direction to pay, Lordship.
And there is a stay to the order judgment and award dated 19/4/2021 passed by the learned labor court, Dibrugarh in reference case number 1 of 2018. This court finds it necessary, essential that the repetition be taken up for final disposal. Accordingly, list the matter on 30/7/2026 for final disposal. Okay. Yes, Mr. Das and Mr. P. Bharadwaj. Mr. Das, tell me one thing. It's very shocking. Why the labor court is carrying out an exercise as a labor department? Because all these people, if I was taking up the other matter where I have yet to deliver the judgment, which ready you get it by Monday or Tuesday. The fact remains that all these people comes under the city commission. If you see all these appointments which have been made all along, which have been enclosed to those proceedings, I find that these are being done on the basis of the centralized rules.
So far as perhaps Labor Department is concerned, presiding officer is the appointing authority, subject to
Maybe appointing authority is different.
selection.
But it is all being done by the government, by the central recruitment cell.
Labor Department, I have got some doubt, my lord.
If you want, I can show you many of these.
Yes, my
Where
lord.
it is seen, because that is why I'm telling you, that is why you find out that those people out there, you see, the case which is pending before me, where I'm yet to deliver the judgment, is a case where whether the register should be given the post op similar to that of the sales data.
Correct.
The full board, the committee have resolved that he should be given. The finance department says no, because he has been appointed separately and all these things. But the fact remains, what could be otherwise seen, that normally all these persons are to be appointed. It is completely independent and right from appointment of a presiding officer to A to Z has to be by the Labor Department. Okay. But in the ROP, if you see, which was shown, it is only the register who is there,
Yes,
not others.
no that.
In the, and because all these people have been brought within the fold of the High Court. And therefore, when you are having appointments out there, a lot of people are being appointed out here by the High Court, appointed and taken up and then posted there, and the appointment order is being given by the government.
Yes.
This is how it is. Now, here what has happened is this. The Labor Department initiates through the presiding officer. And there is nothing mentioned anywhere. Now, if that is being done, how do you then apply if it is not under the High Court under 235? Because that judgment of Justice Umapal,
Yes.
yes, it categorically mentions that they all come within under the High Court under 235. If they come under 235, then how all these things are being carried out? It will have a serious consequence out there. Anyways, he's going to withdraw this petition and make it, and now he'll get additional grounds.
Senior has said that the presiding officer can be represented by.
No. He cannot represent the presiding officer like this. You see, the High Court has to, you come up with that aspect. You wait till Monday. I'm passing a judgment. On Monday, after that, you draft it out. Monday or Tuesday. Oh, Monday. Okay, you come up with that. Now, therefore, what they are bringing in, whom are they bringing? To become people as a senior SR, as those persons who are JA.
Yeah.
Or equivalence. Now, therefore, he didn't know that there is an equivalent notification. There's an equivalent notification issued by the governor,
Yes.
whereby various people have been brought within the ambit of JA, various posts.
Not.
Whether it is done or not, that's it. I'm not on that. I'm not on merits. But this is being done again in terms with by the governor. And this is for the purpose of the Assam District Ministerial Administrative Rules.
Yes.
So therefore, the question is, how this at all the advertisement proceed? And more particularly, all these people are getting city commission.
Yes.
And there are not one, many persons who have been, and various letters which have been received that you all come under the subordinate judiciary of the High Court by the government. And if this government now starts up purely through the labor court without, if this advertisement is allowed by the labor court, without the concurrence of the High Court, it will have a far-reaching consequences.
Yes. Isn't the concurrence of the High Court is required?
100%. It doesn't say even a letter is not being written.
Even if it is not shown in the advertisement, my lord, it has to be there something in the records.
So kindly see what he has done. Page 23 of the petition. Have a look.
Yes, my lord. And one more thing, I think
The
this is a
District Judge
promotional post.
Baksa and all these people have been issued. And the High Court is not aware. How is it possible?
Yes, my lord.
Huh?
My lord, I'll get the instructions, my lord,
It's a
regarding.
very serious thing if it has happened.
Yes, my lord. And I think this is a promotional post. Senior administrative assistant, it is a promotional post.
It's a promotional post. If it is a promotional post,
And
now
it
they
is-
are trying to make it a direct recruit.
It appears like that.
If they are doing it means they don't have the rules also.
Exactly. They follow the ministerial service.
Insurance service. So therefore, how are they going to do it? And more particularly, the presiding officer happens to be a cadre post of the Assam Judicial Service.
Yes, yes.
In fact, none of you have placed the judgment. This is an important judgment, which in fact cleanses the case of the registrar in that case.
Yeah.
It's ready, my judgment.
Yes.
K.J. Bentham. Now, what happened in that case is interestingly, these presiding officers are appointed under Section 7,
Yes,
Labor Code, Industrial Disputes Act.
yes.
but they were not given the pay which is otherwise equivalently given to those who are under as a district judge.
Yes.
Supreme Court delivered a judgment in that regard and say that they are actually they are actually functionaries coming under 234. And therefore, they have to be given the equal pay. No, the district judges. You see, the labor court, these presiding officers actually, if you see, are appointed by the government.
Yes.
But then also, in view of the Justice Rumapal's judgment, they come under 235.
Correct.
If they come under 235, but they were not getting the salary equivalent to that of the district judge, because they were put under the labor department. Then the Supreme Court said, then no, nothing doing.
Pay protection, there was, so far as I remember, Miller, there was a notice.
No, I'm not here. I'm not concerned here. That happened in Kerala.
Okay.
In Kerala, these people were not being granted the alia because they were appointed by the labor department.
Yes. Correct.
Supreme Court said, then no, they are essentially officers coming under Article 234.
Yes.
And therefore they has to be given. Now my question therefore is, if all this happen, the salary which is being fixed at 14,000 to 70,000 with rate pay of 8,000, all these things are being done in terms with the SETI Commission.
Yes.
These persons are getting benefits as per the SETI Commission, the post of senior administrative assistant, as we could see thoroughly in that case. If that be so, then how the labor court has done this without the concurrence of the High Court?
Concurrence, I think, Miller, has to be there.
No,
Because
in fact,
otherwise 235 will be meaningless, Miller.
yes, that is why there is not a single
Whisper in the-
written, anything has been mentioned. Then if that be so, you see, these persons, if they are joining out there, it will be a fresh appointment. Just for example, your case, you join out there, it will be a fresh appointment. Fresh appointment, you lose your earlier service.
Because the advertisement is also a bit ambiguous because it's
Ambiguous.
it says that it's a direct recruitment and they say the seniority come merit.
It cannot be. And if it is seniority come merit without the High Court's concurrence, it is impossible.
And he has invited from all the district judiciary, the candidates from all the district judiciary.
And they are held to come within the district judiciary. It was
Yes.
only the register which was put out.
Exactly.
All others are there. And that is the case which I am dealing with.
Correct.
So therefore, you like to you withdraw it and come up better with those which I have said. Make up your case in that. In the meantime, he will take up instruction, take it up with the register.
Yes, yes.
이건 멜레게다 기소디. 이건 이건 액수얼 이건 멜레게다 기소. 이거 I can seek the proceeding. Mr. P. Bhardwaj, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to withdraw the instant petition with the liberty to refile, inasmuch as there are certain formal defects and various necessary pleadings which were required have not been incorporated. Taking into account the above, the petition stands closed on withdrawal with liberty to refile.
Fine.
You just find out how is it possible.
I'll find out. I'll find.
In fact, in a promotion also, a promotion made in the district judge's court, High Court may not be informed if it's a promotional exercise. But when it's a direct recruitment, Renug hits in.
I don't think this is a direct, peculiar way it has
Yes.
been done, Miller, because if we go by the rules, it says that you have to prepare a zone of consideration from the JAA and all. Then you have to apply seniority merit and now they have conducted Viva Hussain. Minimum benchmark fine, but it appears that the number one merit position, whether seniority has been looked into or not, it's not there.
Because if we allow this exercise to go on, this will not only go against various judgments, but it will also affect the power under 235.
Yes.
Well,
Right.
Oh, Ms. Gail. Please, look into this. This is a contempt matter. Well, response number one is not, nobody is appearing out there. Service
sir.
is otherwise complete.
Yes, sir.
Now, what has happened is this, you must be aware of the judgment of the coordinate bench in the case of this water resource department.
Yes, sir.
The water resource department say that they have paid the maximum amount, but certain amounts have not been paid
Yes, sir.
on account of non-release
Sir.
by you. So therefore, kindly look into this respect.
Yes, ma'am. My lord, going to dispose of matter or my?
No, you should continue.
Oh, you are appearing. If you are appearing, no, we will not call there. I was he was a junior counsel, that is why I was helping. No, when Mr. Samani is appearing,
Yes, yes,
madam,
ma'am.
you don't need to.
Yes.
You don't need to. I'm sorry I'm calling you. Yes, he was appearing, a junior counsel was appearing, I was helping him out, not you. Not at your instance.
Extremely well.
Now we'll see whether respondent number one service is complete or not.
That number from one.
Service is not complete. Take steps.
Well.
You don't appear.
Yes.
Ms. So-and-so appeared on behalf of issue notice upon the newly implemented respondent number 5 and 6. Steps be taken by way of speed post within 3 days. Further to that, perusal of the, further to that, Miss Decker, the learned, Ardeka, the learned counsel appearing on behalf of the respondent number 3 and 4.
2, 3, 4, 4, Your Honor.
Who is also the standing counsel of the Water Resource Department, submits that in pursuance to the directions passed by the learned coordinate bench in the judgment and order dated
27/9.
27/9/2022 in WPC number so and so, along with other writ petition 6707/2021. Steps were taken by the Water Resource Department, and it is on account of certain non-release of funds by the Union Ministry of Jal Shakti. The remaining amount could not be paid to the petitioner. This court have also taken note of that the service upon the respondent number 1 is yet to be completed. Considering the above, this court directs the petitioner to take fresh steps upon the respondent number 1 by speed post within 3 days. List the matter upon service of notice being complete.
My lord.
What did you think?
Actually, my representation before the authority, that has been indirectly rejected. And they have passed the impugn order. So here, in this case, my claim is that the municipality authority has executed in favor of us in 1976, then in 85, then in 1995, last.
Yeah, Mr. Upadhyay, I understand all these things, but the problem arises in view of your appellate court's order.
Yes. That
How
is,
do you take care of that? You
Yes.
see, in view of that appellate court's order, you cannot now again challenge what has been given to him. Not only on the basis that you have already challenged the very decision out there which was set aside and there was a direction to look into it, that is okay.
Yes.
But the fact remains that there were certain lease deeds in those lease deeds which were executed have not yet been challenged.
That now I came to know.
So then you need to challenge those lease deeds by in a civil court.
That observation may be given.
That is the only way out. Otherwise, there is no way out.
Otherwise, they will file non-maintainability petition. Or permission will be granted for filing a revision petition against the order under Article 227,
Against,
against the order of the appellate court.
it cannot be because it is a first appeal. So 227 would not lie. So you have to come on the second appeal. Means then you can very well do so with a liberty, with a application for condonation of delay. Whether it is done or not, it's a different thing. We do.
In case of 227, there is no limitation period. 227, there is no limitation.
But when it is a decree, against the decree, you have to file an appeal. 227 would not lie. But you can obviously take these as a ground that you went there and thereupon this has happened and therefore this has happened. That is the only way out. You can try your luck with that. Therefore, I held it. I didn't dispose of the matter on that day. That is the basic reason for you to think about whether you'd like to go for a second appeal or, but the second appeal has to be gone with the limitation.
Yeah.
Application one. Or you would like to go for a fresh suit, as you have come to learn about this now. From that order, you have come to learn. Because the period of limitation is 3 years, then again. Problem lies there. Because these are deeds. You have to challenge within 3 years as to whether it is a nullity or not. What you would like to think about again?
Yes, I have to think over it. I have to think over it and I have to discuss with my client.
So what did your client say?
Business.
227 is out to the question.
Now, actual fact of, actually, the client has filed the CRP against the trial court order, appellate court order.
You can't file that. You can't file that. It is impossible. Means no court would allow it.
No, that has been filed earlier.
You filed it?
It was
Yes, we
withdrawn
have
by
filed,
them.
but we
It
have
was-
withdrawn.
It was withdrawn by them.
227.
No, not 115. 115.
115 would not lie. Because your suit was not for eviction.
Yes.
So 115 would not lie because an appeal lies.
Appeal
So you
second,
have to
appeal
come
first.
under RSA. And there was a liberty given. When you withdrew the 115, was liberty given?
That's I have no record.
Yes,
Probably.
judgment or assent to WPC ban this.
Yes, very.
We do one thing. We dismiss your petition. I dismiss your petition. Record your statement that you did not know about these deeds.
Yes.
And you have come to know only from that order the existence of these deeds. And these deeds are now available on record.
Yes.
So I don't find any perversity in the order. I dismiss it. However, you had liberty to approach the appropriate forum.
That observation will be given. If your lordship give the any observation in this regard.
No, I'll say that dismissal of this shall not preclude you to approach the appropriate forum challenging this deed if so permissible in the law. Then it is with you to do. Because your main problem is, I'll record it, that initially when you challenge that order,
Yes.
you did not challenge these deeds. You
No, no.
challenged the order.
Only order.
Order. And that order was set aside by the appellate court, by the trial court as well as the appellate court.
Yes.
And the appellate court thereupon directed them to reconsider the representation.
Yes.
And their representation, when it was reconsidered, it was given in his favor. On the basis of two deeds which were in existence at that point of time. One deed I have interfered with.
Yes.
But the other two deeds, I have not done anything to that effect. So therefore, you had no knowledge about it, that is your, you know how to tackle it. Experienced civil court lawyer.
Your Lordship, so far regarding their one deed that was placed regarding this deed that was placed before the trial court, about which the appellate court made an observation that those deeds were for more than 20 years, but they were not registered. So they were not taken into consideration. So if again he go for challenging the deeds, there
But
will
he
be
has not
like,
challenged those deeds, but those deeds were part of the record of the suit.
yes, Your Lordship.
Then only left is the RSA.
With limitation.
Hmm?
With delay condonation.
And the thing is that, Your Lordship, they have never denied the fact that I have been in possession of that particular disputed plot of land, and I have been carrying on business. And I have
But
been,
there's no quarrel with that.
yes, Your Lordship.
That you are in possession, there is not. His specific case is that you were his tenant.
Yes.
And therefore, Dibrugarh municipality could not have entered into an agreement with you separately. That is his case,
Yes, Your Lordship.
isn't it?
Yes.
But the tenancy.
Because my deed is existed at that point of time. Without the modification or cancellation, how the municipality go for execution in their favor?
And there has been one more observation by the appellate court, Your Lordship, that those tenancy agreement which they are saying that they have entered in with the municipality, there has been a clause in that agreement itself that cannot sublet the plot of land to anyone without due permission from the authority. And they have never produced such permission before the trial court, and they failed to prove that I have been their tenant. My payment of taxes are directly to the municipality. I have enclosed in my objection all the tax receipts, Your Lordship. Well back from 1949, 1950, all those taxes are directly paid by me to the municipality, and they have not paid those taxes.
Okay.
Okay, shall heard Mr. NN, the counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent number 4.
Respondent for Your Lordship.
4. Anybody appearing for the state of Assam? So-and-so appears for respondent number 1. Who appears for respondent number 2 and 3, Dibrugarh Municipality?
One is there.
No. None appears on behalf of the respondent number 2 and 3. The present petition has been filed assailing the order dated 11/8/2023, passed by the chairperson of the Dibrugarh Municipal Board, whereby it was opined that both the petitioner as well as the respondent number 4 would continue their possession and occupation upon their individual site premises, subject to the condition that they will remain within their respective site premises. It was also opined that the petitioner as well as the respondent number 4 shall have to abide by the terms and conditions as well as the rules and regulations of the Dibrugarh Municipal Authority in force and any other terms and conditions to be enforced by the authority. First, it is, however, relevant to take note of that the said order was passed pursuant to certain directions passed by this court. To appreciate this court finds it relevant to take note of the brief facts which led to the filing of the present writ petition. It is the case of the petitioner that the Dibrugarh municipality, as it then was, by the lease deed dated 31st of August 1995, leased out a plot of land
21 and
at measuring 21 feet into 50 feet, that is 1050 square feet, being the site number 15 in private map of the private map. Being the site number 15 in the private map, which is included in DAG number 618 of periodic patta number 91, new, within the Marwari Patti ward, Dibrugarh town, Sodor, subdivision of Dibrugarh in the district of Dibrugarh. It is the further case of the petitioner that the petitioner had constructed a shop house over the said plot of land. And the said shop house was covered by municipal holding number 276 of ward number 11 of Dibrugarh municipality. The said shop house was rented out to the respondent number 4 on monthly rent basis on the condition that the respondent number 4 would vacate and deliver possession of the said shop house to the plaintiff petitioner as and when required. This was earlier given, na? The land was earlier given. Was to the lease deed to Nelekipo was given to the grandfather of the petitioner. Grandfather of the petitioner. Pursuant thereto, in the year 2025, in the year 1995, a fresh lease deed was entered into by and between the petitioner and the Dibrugarh municipality
petitioner's father.
in respect to
Petitioner's father and
the petitioner's father and the Dibrugarh municipality in respect to the site number 15 for a period of 20 years with effect from 1/4/1995 to 31/3/2015. It is the case for the case of the petitioner that on the night of 6th of June 1989, a devastating fire broke in, by which the shop of the petitioner was gutted. And the petitioner thereupon constructed the same. With the due permission of the Dibrugarh municipality. Upon reconstruction, the said shop was again rented out to the respondent number 4.
I agreement dated 4/10/1989.
However,
Part of the
part of the shop was rented out to the respondent number 4. However, in the year 1992, a notice was issued by the executive officer of the Dibrugarh municipality asking the petitioner to show cause as to why the lease agreement should not be terminated upon certain allegations. The petitioner could come to learn after submitting the petitioner submitted the show cause notice and further came to learn that these show cause notice was issued at the instance of the respondent number 4. It is the further case of the petitioner that the respondent number 4 also defaulted in making payment. The petitioner was further surprised that in the year 1997,
26/5.
more particularly on 12/6/1997,
26/5.
The petitioner was shocked and surprised upon receiving
Notice 12/12. Yes.
the petitioner on 9/7/1997 was served with a copy of an order passed by the executive officer Dibrugarh municipality dated 12/6/1997, wherein it was mentioned that the executive officer of the Dibrugarh municipality had, by an order dated 26/5/1997, entered into a registered deed
Lease granted to the plaintiff was partly cancelled.
Hmm?
On 26/5/1997, I informed. You will also see the trial court order 56.
Mr. But that court order has also been moved.
wherein it was informed that the registered deed entered into by and between the petitioner and the Dibrugarh municipality was cancelled partly to the extent of 13 feet into 50 feet area, which was under the occupation of the respondent number 4. who was a tenant of the petitioner. Being agreed, the petitioner filed the suit before the court of the Munsif number 1 at Dibrugarh, which was registered and numbered as title suit number 10/2009. Seeking for declaration that the order dated 26/5/1997 passed by the executive officer Dibrugarh municipality in favor of the respondent number 4, granting him lease of the property mentioned in the schedule below, thereby cancelling partly the petitioner's lease agreement dated 31/8/1995 was null and void, semicolon. For cancellation of the lease granted in favor of the respondent number 4, which have been mentioned in the order dated 26/5/1997, as well as for recovery of possession of the leased out premises by the petitioner to the respondent number 4. The said suit was decreed in favor of the plaintiff or petitioner by a judgment and decree dated 14 judgment and decree dated
21st day of March.
21/3/2013, whereby the learned court of the Munsif number 1 Dibrugarh declared that the order dated 26/5/1997 passed by the executive officer Dibrugarh municipality, whereby the lease was granted to the petitioner, was partly cancelled to be null and void, and the Dibrugarh municipality was directed to restore the possession of the plaintiff of the petitioner over the suit premises. Further to that, the respondent number 4 was also directed to deliver vacant possession of the suit premises to the petitioner. Being aggrieved, the respondent number 4 filed an appeal before the learned court of the civil judge at Dibrugarh, which was registered and numbered as title appeal number 32/2013. The learned first appellate court, wide the judgment and order, judgment and decree dated 17/8/2017, upheld the findings of the learned trial court insofar as the issue number 4, that is, as regards the legality and validity of the order dated 26/5/1997. However, insofar as the decision pertaining to as to whether the respondent number 4 was a tenant of the petitioner was interfered with, the learned first appellate court, by the said judgment and decree dated 17/8/2017, directed that Dibrugarh municipality to call upon the respondent number 4 as well as the legal representatives of the petitioner of the to the legal representatives of the plaintiff, bracket there, the petitioner herein, by giving sufficient time and after giving them sufficient reasonable opportunity of hearing to review the impugned order dated 19/6/1997 and thereupon pass a speaking order afresh. It was further directed that the said process be completed within 3 months from the date of receipt of the copy of the judgment and order. The record reveals that the said order, said judgment and decree dated 17/8/2017, passed in title appeal number 32/2013, have not been put to challenge by filing a second appeal. In the meantime, the record further reveals that a lease deed was entered into, a fresh lease deed was entered into by the respondent number 2 and 3 with the respondent number 4 on 1/3/2019. The petitioner, being aggrieved, filed a writ petition before this court.
Petition or not, the other side is fine. Respondent number 4 is fine.
This agreement was entered into with whom? Why did he file?
Because there is a notice challenging the notice.
Oh, okay. I understand. Had entered into a subsequent thereto, it is seen that on 1st of March 2019, a lease deed was entered into by and between the respondent number 2 with the respondent number 4. The records further reveal that the executive officer of the respondent number 2 issued a notice dated 18/11/2020 to both the petitioner as well as the respondent number 4. It is under such circumstances the respondent number 4 approached this court by filing a writ petition which was registered and numbered as WPC number 5638/2020, challenging the notice dated 18/11/2020. This court, by the judgment and order dated 11/11/2022, had disposed of the said writ petition. By holding inter alia that the lease deed which was entered into by and between the respondent number 2 with the respondent number 4 was contrary to the directions passed by the learned First Appellate Court in title appeal dated in the judgment and decree dated 17/8/2017 in title appeal number 32/2013. And under such circumstances, this court interfered with the lease deed dated 1/3/2019. The records further reveal this court, for the purpose of the relevant portion of the said of the directions passed by this court in the judgment and order dated 11/11/2000, the analysis and determination by this court in the judgment and order dated 11/11/2022 is contained in paragraph number 12 and 13, which is reproduced hereunder. The record further reveals that in pursuance thereto, the impugned order was passed on 11/8/2023, which is the subject matter of the present challenge. First, this court has taken note of that upon the filing of the present petition, the learned coordinate bench of this court, by an order dated 24/11 this court by an order dated 24/11/2023 issued notice the respondent number 4 has filed a detailed affidavit in opposition, thereby supporting the order dated 11/8/2023. This court has duly perused the contents of the said affidavit in opposition, as well as the enclosures to the said affidavit in opposition. In the backdrop of the above, this court have also heard the learned counsels appearing on behalf of the parties. And have duly perused the materials on record. From a perusal of the impugned order dated 11/8/2023, it is seen that the respondent number 3 is 3, no? Chairperson is 3. The respondent number 2, after taking into account the documents which were placed by the parties, that is the petitioner as well as the respondent number 4, came to a categorical finding that both the parties had reconstructed the shop building thereon at the individual site premises at their own cost. After the permission was granted on 14/6/1991, it was further mentioned that individual lease deeds were executed by the Dibrugarh Municipality Authority in favor of the petitioner as well as the respondent number 4. Insofar as the petitioner is concerned, the respondent number 4 is concerned, lease deed was entered into on 24/6/1997, 31/10/2008, and again on 1/10/2019, bracketed there, 6/1/3/2019. Insofar as the petitioner is concerned, lease deed was entered into on 2/8/1976 and thereupon on 31/8/1985. It should be 95, na?
85 is there. 85 is also there.
85. And and he has not mentioned about 95.
95 is the last 120 page.
Huh?
120.
Yeah, on page number 120, Your Lordship.
120 with effect from
And
today up
and
to 20
and
years.
on first day of April 1995. On the basis of the above, it was opined that both the parties continue their possession and occupation upon the individual site premises, subject to the condition that they would remain within the respective site premises. First, Mr. N. Upadhyay, the learned counsel appearing on behalf of the petitioner, submitted that the Dibrugarh municipality have not decided as per the directions passed by the learned First Appellate Court. Dated 12/6/19, dated First Appellate Court, as per the judgment and decree dated 17/8/2017, passed in title appeal number 32/2013. As regards the order dated 12/6/1997, inasmuch as the learned First Appellate Court had already upheld the decision of the learned trial court, whereby the order dated 26/5/1997 was set aside, was held to be null and void. The learned counsel, what is this 12/6? There's no 12/6. Whether there is an order of 12/6.
Which one was?
12/6 is there. The learned counsel for the petitioner therefore submitted that it was the incumbent duty of the respondents, number 2 and 3, to decide as to whether the respondent number 2 could have, without cancelling the subsisting agreement dated 1/4/1995, isn't it? 1/4/1995, which was valid up till 1/31/3/2015, could have cancelled partly the lease to grant a lease in favor of the respondent number 4. The learned counsel submitted that merely because of the fact that these agreements were entered into the learned Dibrugarh municipality completely failed to take into account that the lease deed dated 24/6/1997 was on the basis of the order dated 25/6 25 order dated 26/5/1997, which was set aside and quashed, well, which was already declared to be null and void. And therefore, there was an incumbent duty upon the respondents or municipality to decide the same. For contra, Ms. So-and-so appearing on behalf of the respondent number 4 submitted that the impugned order which have been passed duly takes note of that the respondent number 4 had established the shop in the present premises wherein it is functioning since the year 1925, isn't it, madam?
Yes, Your Lordship.
And this would be apparent from a perusal of the order dated 11/8/2023. And more particularly, the finding number 2. She therefore submitted that these are questions of facts which have been adjudicated by an authority. And this court may not like to interfere with the order dated 11/8/2023. In that regard, the learned counsel referred to the various documents enclosed to the affidavit in opposition in support of the respondent number 3's, respondent number 4's claim over the premises. Full stop. This court have given an anxious consideration to the respective submissions. Full stop. The issue which arises in the present writ petition, or even the issue which was to be decided by the Dibrugarh municipality, was as to whether the premises which was whether the respondent number 4 shop is within site 15, which is within site 15, which is the land leased out to the petitioner in terms with the lease deed dated 1/4/1995. Whether Pustak. This court have duly taken note of the order dated 11/8/2023 and do not find the said aspect being decided. Under such circumstances, it is the opinion of this court that the impugned order dated 11/8/2023 passed by the chairman of the respondent number 2 is contrary to the judgment and decree dated 17/8/2023. 17.
Sorry, Your Lordship,
Trial
17.
court 13.
No, the other one. Appellate
Yes.
court,
That was
17.
17/8/2017.
2017.
17.
Passed in title appeal number 32/2017.
2017.
As well as the directions so passed by this court in the order dated so and so. Accordingly, this court therefore sets aside the order dated 11/8/2023. Passed, impugn order dated 11/8/2023, passed by the chairperson of the respondent number 2 as well as by the respondent number 3. I got two things. This order is passed by both persons. Chairperson of the respondent number 2 and by the respondent number 3. And directs the respondent number 2 and 3 to again to respondent 2 and 3 to it sets aside. Accordingly, the instant petition stands disposed of with the following observations. The impugn order dated 11/8/2023 passed by the chairperson of the respondent number 2 and by the respondent number 3 is set aside and quashed. Number 2. The respondent number 2 and 3 are directed to decide the question as to whether the leased out portion of the land, the leased out portion of the leased out premises to the respondent number 4 is a part of the land which was leased out to the petitioner as specifically described in the schedule to the lease deed dated 1/4/1995 and with specific reference to the site map. The said exercise be completed within 4 months from the date a certified copy is served upon the respondent number 3. Only way out.
All right.
May I please, Your Lordship? My
What
lord,
is this?
my lord, kindly see order dated 29/5/2023, my lord. After passing of this order, my lord, 29/5/2020.
Metering become infractions. This has been done, my lord, way back in 2023, and that is the main prayer. Lordship will see page 11.
My lord, from 2011,
11.
from 2021 to 2023, bill were not paid.
That is not the prayer. Lordship will see the prayer.
So, Bill, this is your main prayer.
Yes.
Kindly see the prayer, my lord.
Yeah.
Page 12, kindly see. Directing the respondent authority to make necessary amendments so that petitioner can upload his current bill in the EMR. Or the petitioner can get his pending bill for the work which he has been performing after death of his father.
Have you
This part.
submitted the bill?
Yes.
When?
After this uploading in December 2023.
So, then,
This bill has not been cleared.
so that's a separate cause of action.
No, regarding pending bill, my lord.
So, pending bill will
Not-
be,
not-
you have not asked for the pending bill?
My lord, I have asked for.
No.
current bill in the e-mark so as to current bill I am getting. So
Where?
is page 12.
Yeah, where is that you want to, where is the direction you are seeking that I should direct the payment of bills?
My lord,
Petitioner can upload his current bill in e-mark so as to the petitioner can get his bill, pending bills for the work. Then,
pending bills he has not got, my lord.
okay.
So far with respect to from 2021 to 23.
That's a different case, Mr. Counsel. If you have not got, you have to approach this court and go before the civil court, not here. It's 90 days notice, 82 CPC, 80, and then
My lord, only due to their some technical fault, I am
Mr. Ghosh, this is not the cause of action here. Okay, how much amount?
pending 6,23,000.
Where have we mentioned?
No, this is I have not mentioned.
That's why no prayer.
Because at that point
Or
of time,
Mr. S.K. Ghosh, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the PWD appears for the respondents. The grievance of the petitioner herein is that the respondent authorities have not uploaded his name pursuant to the death of his father in terms with clause 55.2 of the general clauses of the contract, and resultantly the petitioner have not been able to upload his current bills in e-mark so that the petitioner can get his pending bills for the work. Mr. B. Gogoi, the learned counsel, learned standing counsel of the PWD department submits that the uploading was done on.
It was after May, madam. I do not have a specific date, madam. It has been done.
it was done in the month of June to
After May.
June 2023.
Submitted that the uploading has been done in terms with or in the month of June 2023. And as such, the petition has become infructuous. Mr. S.K. Ghosh, the learned counsel, submits that though the uploading of the petitioner's name has been uploaded in the e-mark, but on account of not being uploaded, the petitioner could not submit the bills, and those bills are still pending.
My lord, those bills I have submitted. That has not
Could not submit at that relevant point of time.
yes,
And those bills are still pending.
still pending. From
And those
2020,
bills which have been submitted subsequent thereto are still pending. First, taking into account the relief which have been sought for, it is the opinion of this court that the instant petition has become infructuous. First, accordingly, the petition stands closed. Before parting with the record, this court observes that if the petitioner is aggrieved by the non-payment of the bill after being uploaded, the petitioner, the dismissal of the instant petition shall not prejudice or preclude the petitioner to avail appropriate remedies.
much.
That is
Some instructions, my lord, from my colleague, my lord.
Some development is going on also.
These are for non-payment of dues.
My lord, non-payment also coupled with the fact that, my lord, that my employer made me do the work. But then now he says that I don't have the money because Home and Political has not sanctioned the money.
Who?
Home and Political Department, my lord. These are detention centers constructed, my lord, for foreigners, my lord, detected.
But the
foreigners.
works, there were 5 works, of which 4 have been given up.
No, those are not concerning me, my lord. There are in total 46 works in this particular project. Only 9 of these works which are already completed are before your lordship.
The work lordship beyond the tendered amount lordship. That's why lordship there needs to be approval parties required lordship. An additional work was undertaken by them lordship. So lordship, some deliberation is going on. My lord may proceed the matter after 4 weeks in the meantime lordship, some development. Because there is no administrative approval, just extra work is done also. That is the reason also. And Police Housing Corporation has already submitted the proposal also, and it is under.
The fact that, whatever may be, administrative approval is not there from the finance. But the Assam Housing Corporation did it. And he completed the work.
There is no dispute, even also PWD department has also certificated that they have completed the work also. So
And
lordship,
are you using those buildings?
we are not disputed their amount also. We are not disputed there regarding the work done by them.
Are you using those buildings? Give it to them.
But that's why also after police pilot may fix them after police.
You want those buildings? You pay some amount for the land. As per land revenue rates.
These are detention centers, my lord. No
See the extra work done in the female ward also.
Huh?
Extra work done in the female ward. They have done also extra work. Well, after police loss in a
You do one thing, give it on rent to them. Take it on rent from them.
We'll give the land value, yes, to lordship. We're gonna land part, we have to provide the rent to us lordship.
The land will be as per land revenue. 3 rupees 50 paisa per biga. And you pay around how much? 45,000 per month for each building. Then only things will happen. First of all, why on earth did you allow without an administrative approval? You knew about that.
This was, that part is there also. So lordship proceed the matter after police.
Very serious infractions.
Also. We have completed.
Mr.
there is
King,
no-
why the learned additional senior government advocate submits that another 4 weeks' time is required to give an updated picture in as much as the Assam Police Housing Corporation is taking up with the Home and Political Department for necessary funding so that the petitioners could be disbursed the amounts. The learned councils submitted that there is no denial to the fact that the petitioners have completed the works. And therefore, what is the entitlement can be done only upon necessary verification. Considering the above, list this matter on 10th of August 2026. In the meantime, the respondents in the Assam Police Housing Corporation Limited shall take it up with the Home and Political Department and shall make necessary verification. The respondents in the so-and-so respondent, the Assam Police Housing Corporation Limited shall carry out the necessary verification as regards to the petitioner's entitlement. Full stop. The Assam Police Housing Corporation Limited shall also, after verifying the entitlement of the petitioner, move the Home and Political Department as well as the other departments of the government of Assam so that the necessary funding be received, taking into account that at the instance of Assam Police Housing Corporation Limited, the petitioner have duly carried out the work. List accordingly.
I kept it a part of the report.
Independent verification.
Mention nothing of there.
In fact, independent verification through PWD has already taken place, which is again certified now. Further verification is not necessary.
Let them do it. We'll see what happens then.
Apply.
Wait with the lordship. Lordship, this meter has already become infructuous, lordship.
Huh?
Infructuous meter, lordship. We
Mr.
challenged
So-and-so,
the,
the learned counsel appearing on behalf of the petitioner, and Mr. K. Gogoi, who appears on behalf of the respondent, state. Mr. So-and-so, the learned counsel submits that the petition has become infructuous. Taking into account the above, the petition according stands closed. Interim order so passed earlier stands vacated.
lordship, okay.
Mr. Rathi, again, what happened
Yes,
this time?
my lord, it's the case of penal damage charges, my lord. However,
What charges?
penal damage charges, my lord.
Demerit charges. Go there.
My lord, in this case, I was engaged by the Food Corporation of India. A tender was floated by the Food Corporation of India. I was declared as a successful bidder, and my duty was to unload and load the consignment from the railway wagons and to take over the consignment and transport it to the Food Corporation of India depot. Now, my lords, the railway has imposed a penal damage charges upon the Food Corporation of India. Food Corporation of India has imposed a penal damage charges upon, deducted the amount from my work payment, my lord. And my lord, in this case, I am neither the consignor, consignee, or endorsee. Thus, I am
My
unable.
question is,
Yes, my lord.
you are agreed with the action of the FCI.
Yes, my lord.
Now, whether there is no term in the agreement that you are liable to pay or not.
My lord, there is a term in the agreement. I'm fairly submitting, my lord, which is stating that I'll be liable in case of there is any liability of damage charges, my lord. However, my lord, in that term, it is stated due to my negligence or due to my negligence, my lord. However, the railway has imposed it illegally, my lord. If it has been imposed illegally and that too by an railways, my lord.
Fantastic. Go to the railway trains tribunal.
My lord, I'm neither the consignor, consignee, or endorsee. That's why I'm unable.
But you are affected by the action. Go there.
My lord, as per section 74 of the Railway Claims Tribunal Act, only consignor, consignee, or endorsee can approach to the Railway Claims Tribunal.
Where?
As per section 74, my lord, of the Railways Act, my lord. Only consignor, consignee, or endorsee can approach.
We say that you become the status, you have the status of a consignee
My lord,
or an endorsee. You are an endorsee.
no, my lord.
Isn't it, Mr. Singh?
He is our contractor.
So he's
And
an endorsee.
he is bound by my lord the agreement signed by the contractor, that is the petitioner, my lord.
Understood. Doesn't he become gets the status of an endorsee?
Not as such, my lord, because railway would be the third party, my lord. I think railway has also filed the affidavit in opposition, which the copy has not been served to us. There might be some allegations against the FCI also made by the FCI, made by the railways, my lord. A copy that they have filed, they have not served to us, my lord. And here in the read petition, the agreement copy has not been annexed, my lord.
You have filed affidavit.
And we would like to file. Yes, my lord, we would like to file an affidavit again, and also the reply against the affidavit filed.
This is a 2024 matter, and after 2 years, you are saying that we'd like to file an affidavit.
We have got instruction because nothing against FCI has been alleged by the petitioner, my lord.
You are referring to which section?
74, my lord.
The property in the consignment covered by railway receipt shall pass to the consignee or the endorsee, as the case may be, on delivery of such railway receipt to him, and he shall have all the rights and liabilities of the consignee. That? How is that stops you from going under 36C? Complaint against railway administration. Any complaint that a railway administration is contravening the provisions of 70, charging or carrying or carriage of any commodity between two stations at a rate which is unreasonable, is levying any other charge which is unreasonable, may be made by the to the tribunal, and the tribunal shall hear and decide such complaint on accordance with the provisions of this chapter. Then why you are bringing in a complicated matter to come to the High Court?
My lord, in
There's
74
no
days,
AC in Railways Tribunal.
apologies, my lord. My lord, in 74 days a bar, or else, my lord, I would have approached to the railway.
Go there.
My lord.
Go there. There is no bar out there. Is there any bar?
He has no direct contact with us. He has his relationship with FCI only, Lordship.
No, no,
Himself
because no,
admitted
no,
his
no. The
reputation.
fact remains, whatever may be. FCI has been imposed with the demerit charges, and because of his agreement with the FCI has imposed upon him. So therefore, he has a right to question the demerit charges because of his agreement with the FCI. Isn't it, Mr. Singh?
Yeah, yes, my lord. Yes, my lord.
So we make that clear and allow him to go there.
Yes, my lord.
One question which would also arise, my lord, even in case I am positive in securing that if penal damage charges is illegal in nature, will the Railway Claims Tribunal has the authority to straight away direct the railways to make a payment to me instead of making a payment to the FCI, my lords?
The FCI will return it to you. But you have a cause of action. But you don't have a cause of action here.
Because, my lord, I am stuck between the quarrel, my lord. In the one hand, FCI is not preferring any claims against the railway. In the other hand, they are deducting the payments from my work payment, my lord. In the other hand, railways are
Then
imposing
in
illegal
that regard, if you don't come and go to the civil court, go to the civil court. Why should we look into all these things? Because the fact that they said this is a demerit charge, why should we look into in a writ?
My lord, the illegality.
What is the illegality?
My lord, there's another just one point, my lord. The authority which has imposed the penal damage charges based on the notification, my lord, that authority does not even has the power to impose such penalty, my lord. As per the master circular dated 19 May 2016, only CCM, PCM, and DRM has the power. However, my lord, some ACM Lumding has issued this circular. ACM Lumding has issued the notification for imposition of penal damage only in respect to the.
And what do they say on that aspect? What do you say, Mr. Chakraborty?
Lordship, his own admission is that he doesn't have any relationship with us, para 18 of the writ petition. Lordship.
Have you mentioned this question in your writ petition?
No, my lords, I was recently engaged, my lord. If lordship may permit, I'll file an additional affidavit.
This is beyond the pleadings. You are making a submission.
Last hearing, my lord, I was been engaged in this matter.
So now when I catch hold of you, now you are saying no jurisdiction.
In last occasion, my lord, I was engaged. If I may be allowed to file an additional affidavit, I'll bring this pleading, my lord.
You can't file an additional affidavit and bringing in new things. It is amendment of the pleadings.
My lord, it's the this notification has been annexed by the railway only.
You have not challenged the jurisdiction in your writ petition.
And even he has not challenged the order passed by the Journal Office of the FCI. He preferred an appeal. That order is passed on 6/6/24, page 140. This order has not been challenged.
My lord, I have received the signed copy of the additional affidavit. Lordship may permit, I'll file it within the course of the day, my lord. I have the copy of the additional affidavit now.
Chalo. Mr. D. Rathi, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to file an additional affidavit in the instant writ petition. So taking into account the above, list this matter again on 5th of June 2026. In the meantime, the additional affidavit be filed by the petitioner on or before 25th of May 2026.
Lordship, there is one more case on
My lord,
WPC 1234 of the same party, same issue.
And counsel, you have been engaged there also?
Yes,
Same
lord.
thing.
I'm counselor.
There's
my lord,
also
may my lord,
Yes.
the railways may also be directed to file to serve as an affidavit in opposition which they have filed, my lord.
That I'll do.
Who would not pass these type of orders? Mr. B. Chakraborty, the learned counsels appearing on behalf of the parties also submit that there is another petition wherein the issues are similar. That is WPC number 1234 oblique 2024 filed 26 filed by the same parties amongst the same parties. Taking into account the above, the said writ petition being WPC number 1234 oblique 2026 be tagged along with the present writ petition and listed on the date as fixed herein above.
Thanks, grateful, my lord. Much offered.
There also you
Right.
find
Yes, ma'am.
Muslim Ali, yes. We see Mr. Das. Tell me.
Well, there was an order passed by this court earlier, termination of the contract, but there is a modified the order on 17/9/2025 by this honorable court, saying what we can do it, because in the meantime, the work has been given, remaining balance portion. If your lordship kindly see paragraph 5 of the order,
Having heard the learned counsel.
risk
appear
and
on behalf
cost.
of the parties and taking into account the meetings which have been filed. Whether the petitioner authorities will be entitled to include himself. The reason for the instance is that the petitioner, in the meantime, the authorities of the termination have already issued an of official the remaining part of the month. Interim order.
Now at page 181 of their affidavit, which has been filed by them, they have not indicated to whom they have given the contract. So we said, please give us the copy to us. Today, my learned friend handed over the copy saying that the balance work was given to one of the RB associate on 21/3/2025.
21/3/2000.
So we want to make them a party. What rate, which rate? Because your lordship protected, not risk and cost. We'll make a party. With your, if your
Why
lordship
do you
grants.
need the party? The fact remains that the work has been granted
Yes.
and the work was directed to be completed within 3 months.
3 months. I don't know whether.
The work must have been completed by
That
now.
I don't know, my lord, whether they have completed.
Mister?
or-
This is a very piecemeal work, Mr.
Regarding termination of contract.
No, it's understood. Then the necessity of, if the work is completed, there is no necessity. Now the question arises as to whether you can impose risk and cost. That's the issue. So therefore, why we have somebody else? The fact that you have entered into an agreement, given it to some ABCD, that's a different aspect. Now, while making the payment to so and so, you have may have incurred more amount in making payment. And the resultant effect is that you are going to recover from him. That's the concept of risk and cost. So therefore, now the question is, if you are to do, so why do we need the third party here?
No, sir, we don't know, my lord, what particular cost, what
It
this
is
tender.
failure.
No, that's why we have to see, my lord. What we are saying.
Are you on the quantum of risk and cost or on the action of risk and cost? Where?
No, if it's a quantum.
You are obviously on the quantum.
Yes, of course. Quantum.
On the action of the risk and cost. So how much amount is not the question.
No, that's right. My lord, please look into it, the manner which they have proceeded. 17/12/2024 is the termination order. It was some order, then the court felt that no, what we'll do is modify to the extent because risk and cost is that was the only factor. Now, in the affidavit which has been filed by them, they did not indicate who is the contractor. We told the court we wanted to know and what is the rate that has been fixed, my lord. Today they have filed this, my lord. Who is the contractor?
So they have given it at
now today itself, now in the court they have given to me, my lord.
So now the question is whether the termination is bad and whether the termination with risk and cost is bad. That's the question.
Correct, my lord. No. Well, let me see. I got it today, my lord. Let me have instruction with my client. This is what they have done. 3 months time, we don't know what is exact state of affair in this, whether they have completed the work or not.
Let me have instruction, my lord. Today in the court, they have handed over.
Regarding the risks and cost part, my lord, that we should be a penalty otherwise. Whether they are going to impose that on the petitioner or not, or they would like to raise the matter at this stage itself. And let me have the instruction that because otherwise will terminated, my lord, work executed by a third party. No stay order by from the honorable court. Then my lord, nothing.
So
in
the
it, my lord.
question of, no, the question of interfering with the termination does not arise today.
Yes.
Because the work has been done by somebody. But the action of termination would be looked into only to the aspect that whether the action is such that you can, was it justified or not, or whether it is arbitrary or not. If it is arbitrary, then obviously the termination would be bad, and consequently the imposition of risk and cost will go. That's all.
Correct. Absolutely correct.
Yeah.
But
Right.
Mr. Das wants Mr. Muslim Ali to take instruction. So therefore, we have it sometime in the month of, well, December.
To do that, my lord. June, my June.
Mr. B. Gugoi, the learned counsel appearing on behalf of the PWD department has placed a notice to proceed with the work issued to one MSRB Associates. The said document is kept on record and marked with the letter X. A copy of the said document has also been furnished to Mr. So-and-so, the learned counsel assisting Mr. D. Das, the learned senior counsel. Who's taking into Mr. D. Das, the learned senior counsel next year, submits that he would like to obtain instructions. List the matter again on 3rd of June 2026.
In this case, sorry, sir. Interim order will continue your lordship.
Interim order
79.
is there. Sounds like me.
There is order.
Now, I know that whether it was not passed in the disposal.
79, 2002.
I think I passed it till the disposal.
Tendency of the available be civil preview. Finalization of present.
No, the interim order is there. Accordingly, this court directs the respondent not to impose any risk and cost upon the petitioner till the finalization of the present dispute. Now,
Right.
if you want, we can extend.
No,
No. Then it was made till the next date.
Yes.
Okay, now you don't have an interim order.
Your
No
lordship,
interim order then. What's
this
the
order was
extent?
passed on 79, 2020.
Understood. Thereafter, I passed an order that till the next date, somebody mentioned the matter. Mr. P. Sharma was there and he made the mention that for adjournment. So I said, okay, interim order till the next date we gave it. And thereafter, there is no interim order. So under such circumstances, this court have modified that order. We don't have an interim order. You take over the money from him. Okay. Taking into account that this court had already passed an order on 17/9/2025 that the respondent authority shall not impose any risk and cost upon the petitioner till the finalization of the present dispute, there is no necessity for passing any further interim order.
Dispute, in the dispute is. Maybe.
File our affidavit today during the course of the day. Therefore, the same is not moved.
You have filed affidavit today. On which
The same is not
IOC?
report today. We have filed it today during the course.
On behalf of IOCL, they filed their opposition. I'll need to file a reply letter, voluminous.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the affidavit has been filed on behalf of the IOCL today. And the petitioner would like to file a reply. Taking into account how long?
3 weeks, lordship. 3 weeks, lordship.
Matter
It will be somewhere in
pertains
the
to
month
what?
of June.
Matter pertains to?
Lordship, the matter relates to a fact that the petitioner before the lordship was earlier a proprietorship firm. During the subsistence of the proprietorship.
Your matter has become infectious.
No, Lordship, the work is not yet complete. The work in question, which was cancelled from me, has not yet been handed over to anyone.
But there's no interim order passed.
There's no interim, but they have not handed over the work to anyone. The work also has not been allotted to anyone.
It's okay, but
EMD
the
and
fact
security
means
still
that it's a case of pushing of the termination.
Lordship.
There's no interim order passed.
No, Lordship.
You have not sought for the interim order.
We had, there was a prayer for interim,
But
unfortunately.
you never sought for. Anyway, okay, leave this matter on 5th of August 2026.
Okay,
In the meantime, the reply be filed.
Can it be in the month of June?
June, no. June is packed. There's no matters. You see, I'll show you how much is June.
Towards the end of June, Lordship, any day.
June, 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 June. June. Okay, 19 June.
All right, Lordship. All right.
Mr. Hawk, what is this?
That in this case, my lord, the executive engineer has probably filed the affidavit. I have received copy today, my lord.
What do they say?
Well, here, my lord, the work was executed by one party now. Petitioner from nowhere has come up and is claiming, my lord, the payment for that particular. She is neither a partner, my lord, to that person, my lord, nor is a wife. Legal hand. He has expired. 5 works were allotted, my lord, out of.
Who did the work?
It was.
They are saying that let Ajuddin, one let Ajuddin.
Huh? Who did the work?
According to them, my lord, let Ajuddin, my lord, and according to the petitioner,
Ahmed.
along with Ajuddin, my lord.
No. There is no such document, my lord.
That is why, my lord, because no formal work order was issued, my lord.
What? What did you do?
We will have a look at my copy. What copy I have made photography of the affidavit.
Work order issued where?
No formal work order received. On verbal instruction, the works were completed.
How do you do verbal instruction?
My lord, at the instruction of the district commissioner.
Then go to the civil court.
Para 5 plot will see page 36. Para 5.
Yes, that's what we did. Everything.
So the contractor was one late Ajuddin Ahmed.
He expired
claiming
on
that.
26/8/2020. He expired on 26/8/2020. And the legal hair certificate, Lordship will find in our affidavit at page 73.
Of course, my lord, legal hair, my lord, answer will be not there.
All, my lord, the bill is to be paid, my lord, will have to be the legal hair.
So the contractor was some Ajuddin Ahmed.
They are saying, my lord, but Ajuddin Ali has no contractor license, my lord. Anju got the license, my lord.
Who?
Anju Deka, the present petitioner, my lord.
Anuj Deka.
Yes, my lord.
Anju Deka.
Yes, my lord. And my lord, your lordship come to page 13, my lord, of my petition, my lord. There is a part of the, my lord, declaration gone by the wife of the Ajuddin, my lord. Page 13, paragraph 5, my lord. That is shown by Jerina Begum, my lord, the wife of Ajuddin.
Page
13, 1.
13.
Yes, sir. Is a declaration, my lord. There Begum, my lord, who is the wife of late ITC, my lord. And come to paragraph 5, my lord.
So this repetition is filed as a power of attorney on the.
No, my lord, not power of attorney, my lord, because the Anjuteka is the having the license for that, contractor license. The work was done under under Anjuteka, present petitioner, my lord. Ajuddin and Anjuteka both completed the work, my lord. After during the process of work, my lord, Ajuddin died. Subsequently, the petitioner had to carry out the work.
When did you carry out?
In the year 21 itself, my lord.
Huh?
21 itself, my lord.
When?
In the year 21, my lord.
21.
Yes, my lord. In the year 21.
But kindly see paragraph 3 of that same document.
My lord.
That at the leaving time of my husband, late so and so completed. He completed all these works.
Yes, 2 works. That is in a affidavit. Out of 5, 2 has been completed by the husband.
There was the cost source. We give some cost. This is the unnecessary type of.
My lord, let the affidavit come, my lord.
No, not necessary. We let us not look into this affidavit. Without affidavit, we discuss.
My lord,
Without affidavit, you are lucky enough somebody have issued notice. See, somebody was very kind enough to issue notice.
The wife is not a party hearing. The document they are relying upon, she is not a party hearing.
There's nothing on his record to show that he has any to do with
my lord,
it.
Ajuddin has
Let him take back the affidavit.
Ajuddin has no contractual license, my lord. They cannot offer work, my lord.
So what? Where is one single document? So you see, the fact remains that show me a single document of you having a correspondence with the PWD. Where? This type of requisitions is absolutely.
My lord, here in the communication, my lord, page 64, my lord.
Page
64, my lord, the affidavit, my lord, of the affidavit.
No, affidavit I'm not looking. Here, where?
In this petition, my lord, I have also seen, my lord. There is no name in the petitioner, my lord.
Tell.
Because those works are done on the verbal instruction, my lord. No formal work order.
If you have anything, go before the civil court. Nothing to do here. These type of requisitions we dismiss with cost. Heard Mr. S. Hawk, the learned counsel appearing on behalf of the police. Mr. So-and-so, the learned additional advocate general as well as the Sam represents the respondent numbers 1 to 4. The present petition has been filed by the petitioner claiming an amount of rupees 58,21,553 from the respondent authorities on the ground that the petitioner had completed various works and was therefore entitled to the said amount. This court have perused the entire petition, and there is nothing, there is not a single document issued by the PWD authorities whereby the petitioner have been shown to have been issued any work order or even have been, there's not a single document to show that the petitioner have been issued any work order. There is also nothing on record that there is any, that the PWD authorities or the other respondent authorities have acknowledged that the petitioner have carried out any work. On these materials, it is the opinion of this court that no writ can be issued inasmuch as even prima facie and no writ can be issued. Accordingly, this court does not find any merit in the instant writ petition for which the writ petition stands dismissed. So before parting with the record, this court, however, observed that the dismissal of the writ petition shall not preclude or prejudice the petitioner to approach the appropriate forum if so advised under law.
Well,
Yes, Lordship. So in this case, I am supposed to file an affidavit, but without affidavit also Lordship can dispose it of, because it is only dispute. I could not file the affidavit Lordship. Instruction is there. Without affidavit also it can be disputed.
Mr. P. Sharma, the learned standing counsel of the Fishery Department, submits that the Fishery Department would not like to file that. Don't make that. You are making that submission. I am not making that submission. That without the affidavit also this court can dispose it of.
But I will, in that case, Lordship, I will find.
Final opportunity already gone.
Lordship, that is,
So if I have to give you another opportunity means you have to pay cost.
Lordship, in that case, Lordship, I will argue the matter on the documents annexed on the petition also. I will argue that.
So therefore, I am saying that you are not going to file the affidavit. I have to conclude there is no pleadings.
But I have the instruction, but just some technicalities, Lordship.
So you don't have the instructions. Tell me what to do.
Yes, Lordship, go for it without affidavit. I can produce a record, Lordship, on that. Give me a chance to produce the records. I will produce the records.
So you are not filing the affidavit.
In that way, it's okay. In that way, I will not file affidavit, will produce the records.
That is what I will record it, because later on, if the matter comes up before any other court, the court may again allow you to
In that case
ask
also,
for
Lordship,
time.
I may play one, Lordship, one.
Don't pray anymore.
I know what records, Lordship, last time.
What is the matter about?
My lord, we are running the fishery, but my lord, respondent number 9, your lordship will find. Relentlessly, my lord, he is fishing out in that quite illegally.
Who?
Respondent number 9. And we have been making a representation before the DC, Joint Secretary, the SP, but they are doing nothing.
Number 3 saying in the affidavit.
My lord, your lordship, in the
Let's see the
affidavit, they did
affidavit
not
of
say
the
anything.
respondent number 3.
Yes, they have filed one affidavit, but your lordship will find that what action they have been taken pursuant to the order passed by this honorable court. They did not do anything, my lord.
But we have taken action, my lord. We have written to the SP, and SP have taken the action, my lord, and now, my lord.
Because the moment I say one single word that there is no action taken, the next thing is that he's saying that I cannot pay my kiss money.
No, what happened, my lord?
Already.
Your lordship will find from the record for 4 months.
In fact, the fishery has no business. You have handed over the possession. Because it is not the question of any settlement or anything. It is the question of whether any action has been taken upon the respondent number 9 for carrying out some activity. That's the issue.
Yes, yes.
And if they have taken any action, matter is over. So that is it.
After receiving notice from this, my lord, honorable court, my lord, my lord, action has been taken.
Where is it?
My lord, we have filed the affidavit by respondent number 3.
We have forwarded to the superintendent. Kindly come to page 83.
Yes, my lord. Yes, my lord. This and for temporary take necessary action, my lord, but
Then what happened after page 83?
my lord,
That was in 2022. We are concerned now.
my lord, actually, we have taken, though we have an instruction from the SP, my lord. There, he has given the reply against paragraph 22. The matter was inquired, investigated by Pancharatna River Police.
Paragraph?
and Malad Lordship will not file there, Malad. We have received the instruction from SP, Malad.
When?
Malad, it's long, but that, Malad, after this, I quit and Malad. May I talk? So action has been taken, Malad. Now, Malad, after that, after this, Malad, no illegal fishing. Malad.
No, Malad, it's a quite Malad incorrect statement, Malad. And why they are playing hide and seek?
22, Malad.
You're playing hide and seek without filing this thing and you are uttering on this.
Please to grant me 1 week time in that case, Malad. But for SP, Malad, if it.
You bringing this on record by
Malad, deeply opposed.
So this court have duly taken note of the dispute involved in the instant proceedings. Inasmuch as it is the case of the petitioner that though the petitioner was granted the settlement and handed over the possession, but on account of certain illegal actions on the part of the respondent number 9, the petitioner have not been able to carry out the fishing activities in terms with the settlement. First, Mr. P. Sharma submits that taking into account that the action on the part of the on the part of the police administration as well as the district administration are the issue, and which have nothing to do with the fishery department, it may not be necessary on the part of the fishery department to bring on record its stand. Be that as it may, so this court have also taken note of that an affidavit has been filed by the respondent number 3 on 19/9/2025. A perusal of the said affidavit and more particularly the contents of paragraph number paragraph number 15 shows certain actions being taken up sometime in the year 2022. There is nothing mentioned. This court, upon inquiry being made upon Ms. Yuda, the learned additional senior government advocate, the learned counsel submitted that she has received an updated instruction and would like to file an affidavit in that regard. List this matter again on 12th June 2026. In the meantime, the affidavit be filed on or by the superintendent of police, na?
Yes, ma'am.
Walpara, on or before 10th of June 2026. Okay, Mr. Sharma, I have taken care of you properly. Yes. Yes, Mr. Ganguly.
This matter, there is some settlement going on between the petitioner and the private respondent. Some
amicable solution? What is the matter about?
Today, my learned friend has handed over an agreement, Malod's copy, that there was some.
What interim order? Our hope the learned counsel appearing on behalf submitted that affidavit has been filed. What is this? Who? Matter amicably settled.
No, that instruction I don't have, Malod. He has handed over the copy to me today. I tried to contact the petitioner. Apparently he is not in. He's in Bangalore, Malod, for some treatment. Lordship may fix it up after a few days, Malod. If it is indeed settled, because there is a history between the parties, Malod, which cannot be ignored.
Maimul Hawk. Maimul Hawk. Maimul Hawk. Let us see his signature. It has been submitted on behalf of the respondents, private respondents, that the matter between the petitioner and the private respondent have been amicably settled. In that regard, an agreement dated 6th of April 2026 have been placed before this court. Give me a photocopy.
Color Xerox. It's color Xerox.
Oh, this is colored Xerox. Oh, good. The said agreement is kept on record and marked with the letter X. Mr. A. Ganguly, appearing on behalf of the petitioner, submits that an opportunity may be granted to him so that he can inquire about this agreement. He have also been furnished with a copy of the said agreement. Taking into account the above, list this matter on 13th of May 2003, on 28th of May 2026 for an update.
There is an interim order that may continue. There is an interim order status quo.
What interim order?
Let that continue. Vacate on 20th.
Interim order passed earlier shall continue till the next.
Deep.
Organized law.
This is item 42. Yes, madam.
My lord, we have filed this petition
Huh?
against the cancellation of work orders.
Against the?
Cancellation of work orders awarded to the petition. As in-
Yes, Sahu.
Things are completed in this case. No? So we have filed a affidavit, they have filed a reply also.
So you file affidavit
Lots.
and
I got 15 of my affidavit losses is relevant.
and what do they say? Finance say?
Finance is a party.
Finance, Mr. B. Gogoi, what do you say? You appeared in this matter. Now here was a case. There were two contracts. These contracts were of a particular value. But you have a standout there, na? If it is below 20 lakhs, you can bifurcate, you need not go for online bid or something. So what they did is, I think they went for made it 4 contracts of the two.
2 works have been made, 4 works.
4, so that it
Segregated.
comes below 20 lakhs
Yes,
and they can give their person to their choice.
yes.
That's the
So
allegation.
there is intervention by the chief engineer, Lordship. He has cancelled that all work orders. And there is the inquiry also, Lordship. Inquiry was conducted by the
So these 4 work orders have been cancelled.
Lordship. This is why they have come, Lordship.
But their work orders were
Yes,
cancelled.
Lordship.
No, I'm not on that. But
No,
the
this
question
work-
they have raised is as to whether it is permissible. Let's see, what do you say?
The concerned executive engineer has done it, Lordship. As Lordship has said,
Now tell me, what is your case in your affidavit?
paragraph 15, Lordship. May I read it, paragraph 15, Lordship? That with regard to the statements made in paragraph 17 of the petition, the deponent begs to state that the deponent had received a complaint from some of the contractors alleging that the then executive engineer, Nalbari Division 1 had committed irregularities in the floating of NITs and issuance of work orders by violating procurement rules. Thereafter, an inquiry committee was constituted by this office letter number so-and-so dated so-and-so, comprising the additional chief engineer, implementation, so-and-so. Accordingly, the committee inquired into the matter and submitted an inquiry report. In the inquiry report, the committee mentioned that the then executive engineer, Dharmapur Borpetri Nalbari Division 1 had quoted 3 NITs in violation of the procurement rules. The report further reflected that the concerned executive
So
engineer.
you have challenged those work orders.
Yes, my lord.
Now that has been cancelled by you.
Lordship.
So nothing remains.
Lordship. No, Lordship, the work order issued to the favor of the petitioner, that has been cancelled by the chief engineer.
Work
Oh, they have challenged that.
Yes, Lord. Lordship, kindly see the last page 137 of the petition, Lordship.
With reference to you are hereby informed that the NIT dated so and so, based on which the aforementioned work order was issued to you, have been cancelled as per the direction of owner. Now then, why did I pass such a long order? There should be some reason behind. First day, the matter getting adjourned makes it clear that the matter will have, the petitioner's case is very weak. And by the case of the Iman, is that pursuant to a notice inviting tender so and so, so and so, so and so, which is the case of the person that although the contract agreement was entered into, but the site was not delivered, however, of a Sunday on Iman, and issued the cancellation in respect to which we have not witnessed is agreed by the action of the end, Python and conflict during the reason for which we can take it. What on the contract of project to check the conflict. Oh, yes, Mr. Bingoboy, I asked you to bring on record this stamp because what is happening is the finance department has to be strict with these authorities. That is why I have asked you, although you were not a party also.
Not party, not a party. Lord.
Not a party, but I have asked the finance
yes.
department to bring on record its stand because something strict, this direction has to be given to this irrigation department. Because in order, if you keep on bifurcating, it was two contracts, they have made it 4. So that it comes below 20 lakhs and thereby can be given to everybody without tender. This is what has happened.
Yes, sir.
In fact, the petitioner should have silently withdrawn the writ petition after my order. So we dismiss the petitioner's case. Paragraph 15.
But my lord, my prayer is that even after cancelling the work order, so they also they handed over the work site to some other contractors.
Without tender.
Yes, because the SNIT was already cancelled. And after that also they have handed over to some.
That's a subsequent cause of action, na?
Yes.
Whether a new tender has been floated or not, or without tender has been given to somebody, isn't it a subsequent cause of action?
But without giving any notice to the petitioner, they have cancelled the work order.
Understood, but if there is, if it is in gross public, the requirement is, if the public interest is affected, then why should this court interfere? My question is that, madam. Because I asked the finance department to put on record its stand only for the purpose that there has to be some strict guidelines issued. That is why I passed that long order. Nothing to do in favor of the petitioner. Finance department, what do you say? Something needs to be done. You take this order and do file something out here, or ask them to pass some notification to the effect. Then the thing will improve. But then if these executive engineers keeps on doing all these things, then it will be creating the very Assam Procurement Rules Act, and the rules becomes then useless.
They are trying to bypass it.
This is how they made it. 2 contracts of 40, 80 lakhs or 79 lakhs, they made it 19 lakhs, 99,000.
Just below 20 lakhs.
We don't dispose it of today, but I think just.
It can indicate some observation in the final order itself today.
Yes,
I will come here to the commission.
No, not only that, I have already informed that. Na?
I have reflected, I have
Yeah, because I have show him the order, paragraph 8 of that order, last order. Have you seen my order? No.
It can be, it.
In fact, the repetition was kept pending only for one reason. Nothing to do in favor of them. For the finance department to have a look what is happening under their nose. The reason why I want to keep it pending, once we dispose it of now, it goes out of my head. Now you see, this order was passed when? A long time back. 4-8. We are today almost a year back. So therefore, nothing has happened. And if I dispose it of, nobody is going to give a copy and it will, nothing will happen.
I have communicated, well, let me see.
You look into it as so yeah. So let me do one thing. Let me put it as to what that you have not filed the affidavit. Directs the heir to bring on record their stand. So that thing, you bring it on record by doing something to the effect. Once this is being done, then things become better at a later stage. So, this code by an order dated 4/8/2025, I directed the finance department of the government of Assam to bring on record their stand as to whether the course of action which was adopted by the executive engineer, concerned executive engineer of the irrigation department was permissible of bifurcating composite contracts in order to dispense with the online bidding. However, they said no affidavit has been filed in that regard. Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the finance department, submits that an affidavit will be filed on behalf of the finance department, bringing on record their stand. List this matter again on, can we do it on 10th of June? On 10th of June, 2026. The affidavit be filed on or before 8th of June, 2026.
Right, endorsement. This matter relates to, my lord, non-payment of the remaining balance amount for the supply of hybrid seeds by this petitioner to the, my lord, managing director of, my lord, Assam Seed Corporation.
What does the agriculture say?
Lordship, it's a admitted amount, Lordship.
They have filed,
Maybe, given, Lordship, I have filed affidavit, Lordship. In para 6, Lordship, page number 48. We have mentioned.
Affidavit 3, response number 3.
Lordship, on behalf of the Director of Agriculture, Lordship.
So you have admitted 20,75,000.
Lordship.
Huh?
Lordship.
That is the total amount admitted,
yes, my lord, 40 lakhs.
not 40 lakhs, 20 lakhs.
20 lakhs.
Now, total was 40 lakhs. Out of this, part payment has already been made. Now,
The
as per,
balance admitted amount is so and so.
Lordship.
Paragraph 6 to Puri, our agriculture is going to say, with the direction to the payment has to go by agriculture to this Assam
Yes,
seed.
yes.
And Assam seed, then they will disburse all within 6 months.
Lordship.
yes. Same order, your lordship, have passed recently on 22/4/2026.
Which is agriculture.
Yes, my lord. Same order.
এখন দিয়ে দিব। Give that order.
Yes, yes.
What is this?
Please, your lordship, the respondents were to obtain their instructions as regard the demand proposal, lordship, for sanctioning of the admitted outstanding bill, lordship.
Well, I appear for the PWD here, my lord. Here, my lord, the amount will have to be disbursed by the Director of Printing and Stationery. And my lord, the PWD has sought for a proposal from them on 2/1/26. That's the instruction I got today. I pray for 7 days time to have the updated instruction from the my lord director, who is the respondent herein.
Yes, sir. He wants money for what?
Lordship, the admitted amount outstanding bill, Lordship, we have completed 27% of our work, Lordship, the contract work, Lordship. That is the at annexure 9, your Lordship, you can see our
The amount of 30 lakhs 47,061.
that is the
This
outstanding.
is which department?
It will be respondent number 4, madam.
Which department?
It is the director of printing and stationery.
We pay within 6 months. Verify and pay.
Yes, that can be. My lordship will keep this part on record and then. Respondent number 2 and 4 will be the competent authority, madam, to do the needful.
Why is asking for 30 lakhs? Here the tender value is much more.
No, my lord, admissible amount is, my lord, according to the petitioner is 30 lakhs 47,061.
Oh, there, that amount, not 30 lakhs, huh?
Yes.
Okay, in the completion certificate it is given.
Page 232.
After verification, that may be added because, my lord, in the midway, my lord, the contract had to be terminated because it was, he could not complete it in time. So maybe, my lord, some penalty may be there. That's why I'm saying, my lord, he has dropped the player for, my lord, reallocating the work to the petitioner that they have dropped. They won the balance amount only. The last
Then if he has not completed the work and if you have terminated,
Yes.
the question is different.
Yes, that's why
We
I'm saying.
cannot apply the same yardstick.
Yes, not a.
So therefore, you give an updated instruction. Now here, an order was passed by the learned coordinate bench to the effect that Mr. P. Gowat, learned additional advocate general, has sought listing of the case on so and so to place an updated instruction as regards the demand proposal for sanctioning. If that is the submission you made, that means that you don't want to deduct.
Well, apparently from this, my lord, communication, it seems, my lord, they are seeking, my lord, for a demand proposal on that particular exact amount, my lord. That is 30 lakhs.
This is an old document.
No, according to the PWD authorities, my lord, subsequent to this letter, my lord, no proposal has
See,
been.
the matter came up on 1/4/2026. This document which you are placing is of 2/1/2026.
That's why, my lord, subsequent to that, my lord, nothing has been submitted to us.
So it means you have not come up. So why you should not pay?
Proposal and communication says, my lord, that.
No, verify and pay.
Verify and pay, my lord.
Better verify and pay. And while verifying his entitlement, it will include any dues payable to the PWD also.
Lordship,
So verify and pay.
Lordship, if I may be having one thing, Lordship, you kindly see page 232, Lordship, for the contract, the repetition, Lordship.
Page?
Lordship 232, last. Lordship, with respect to the present.
This is the document he's showing. That is that document only.
It has already been written here that certified that all the works has been.
This is 2024 now. This his document. Kindly give a copy to him. Because again, Mr. Gogoi will place the same document to him.
No, this is 2/1/2026.
2006. See the next page.
Yes,
See the next
completion-
page.
completion.
This is the page.
Yes, yes.
You are referring to that page only. I've seen.
Lots of.
He also wants to show that. But the question is, here, this is the completion certificate given by the executive engineer. So therefore, the question is, they will make the verification and make the payment within 6 months. While carrying out the necessary verification, the respondent shall also take into account while carrying out the verification, the respondent shall also take into account that on account of termination of the contract, as to whether there is any penalties payable by the petitioner to the respondents. Work to be said of us.
In this matter, the petitioner had filed an appeal under Section 38 of the Assam Public Procurement Act on the ground that the party, the private respondent who was granted the contract, had a pending inquiry which was not disclosed during the bid evaluation process. Now, your lordship had directed that the appeal should be disposed of. Now, till date, the appeal has not been disposed of, though hearings have been held. This is the last communication from the secretary. Get their hands on. There, the secretary has admitted that indeed there was a pending inquiry against his bidder, which was not disclosed during the evaluation process. So that is precisely my case, your lordship, that if this was disclosed, then the bid of the private respondent would have been rejected.
Rejected.
It should have been rejected.
Now what is happening?
He has been awarded the contract.
Now you have challenged it.
I have challenged, I filed an appeal under section 38. The appeal, they are sitting over the appeal. Your lordship.
No, my lord, may I place the facts? Initially, the private respondent was allotted the work in the earlier tender. Same lead petitioner approached the honorable court challenging that, my lord, he is not qualified to be technical, he is not technically qualified. This honorable court finally interfered with that, my lord, tender process. So, my lord, whatever so-cause we have issued, it goes along with the entire tender, my lord, because that work order has been cancelled by this honorable court. So there nothing remains, my lord. They in their own proceeding, my lord. In earlier case, my lord.
And then
my lord, it was decided that instead of, my lord, issuing tender for the entire state, my lord, for all the medical colleges, it will be individual tenders by each of the principals of the colleges. Now, this is, my lord, this is pertains to Nalbari Medical College. Now they are claiming, my lord, that during that particular earlier tender, where since, my lord, a so-cause was issued, how could he be now eligible to participate in this tender process because there is a proceeding pending? Perhaps, my lord, that stand will not lie because, my lord, that tender process was interfered with by the honorable court. And along with that, my lord, entire so-cause and all proceeding has gone.
But why haven't you disposed of the appeal?
My lord, yes, my lord, on 2/5, my lord, a report has been called for from the director. Lordship will give a time frame, my lord. 2 weeks, 3 weeks, my lord. Let the authority complete it, my lord. That document he has placed, my lord. I am also holding the same document from the authority.
But Mr.
2/5.
Goi, does it befit this court to pass an order giving a time frame
I
when
understand now.
on 3/12/2025, I made it returnable on 7/1/2026 and further directed as an interim direction, this court only directs the respondent number 5 to dispose of the appeal filed by the petitioner
My lord, Lordship will in that case.
as per the mandate of the said provision on or before the next date, if not yet disposed of.
First week of June, my lord, I will intimate, my lord, that anyhow it should be completed in 2 weeks. I will intimate, my lord. Let it be on first week of June, my lord. Lordship will fix it.
Now, Mr. K.P. Pathak, the learned counsel appearing on behalf of the petitioner submits that the petitioner herein is aggrieved by the inaction on the part, is submits that the petitioner had filed an appeal under section 38 of the Assam Public Procurement Act 2017. Before the appellate authority. However, on account of the appellate authority sitting over the said appeal, the petitioner was compelled to approach this court. The learned counsel appearing on behalf of the petitioner further submits that not only the respondent number 5 is sitting over the appeal, but also in appeal. Not only the respondent number 5 is sitting over the appeal filed by the petitioner, but in spite of speculative directions passed by this court in the order dated 3/12/2025, the respondent number 5 have not cared to dispose of the appeal, which apparently appears to be a willful and deliberate violation to the order passed by this court. Mr. B. Gogoi, the learned counsels appearing on behalf of the respondent, submits that he would obtain the instructions as to whether the appeal has been disposed of or not. Till date, list the matter on 8th of June 2026. You know what will happen.
I understand.
Dear brothers, against the illegal settlement.
What are brothers?
Both are
Taking into account both
Both.
initial name starts with an M. ends with the ali, and the writ petitions are 7023 and 7024.
Brothers.
Brothers?
That's the
Oh,
brothers.
yes, they are
Brothers.
brothers. Ah, I remember. I have passed some order in this case earlier. It was given to somebody else, na?
Yes, ma'am.
Ah,
Babul.
yes, 7 and 8. Yes, I remember this. Now, tell me, what is there?
Lordship, we have received instructions, so which time may be given, we'll find our appeal. Otherwise,
1 week?
Lordship.
Ms. Enbora, the learned counsel appearing on behalf of a PNRD, the standing counsel to the PNRD department, submits that within 1 week's time, the affidavit would be filed. List the matter again on 5th of June 2026. The affidavit be filed without fail
Lordship.
on or before 25th of May 2026. Yes, police.
But this case relates to the non-renewal of the gun
Arms
license.
Thanks, ma'am. My lord, affidavit, I'll receive it by today, my lord. So I'll file it by Monday, my lord.
Ms. Yudas, the learned additional senior government advocate, submits that the affidavit would be filed on behalf of the police department or respondents by 18th of May 2026. It's the matter again on 25th of 29th of May 2026. Liberty given to the petitioner to file reply, if any.
Petitioner is aggrieved by the cancellation of his flat price shop license for the cancellation order was filed the
Malor focus notice was issued, Malor. After that, Malor cancellation has been done.
bloody report and inquiry report was not furnished to me.
Where? Did you ask for the so-called inquiry form? Let's see your reply. Oh, where's your reply? Then there only we'll come to know. No. Prejudice has to be shown, Mr. Counsel. Not like this.
In the appeal note, see.
Then file an appeal. You file
Yes,
it already.
appeal already filed.
So how many months you have been, what is the allegation against?
Litigation is for 2 months, for July 2022 and August 2022. We did not maintain the stock requirements. For those can take payment for the time notice, we have simply priced by maintaining biometrics.
Okay, have you brought on record your reply?
My reply I have filed, but there are few cases similar to that pending you lost it from 25th.
When?
On 25th of May.
Okay, I'm not there. Anyway. Okay, list this matter on 25th of May 2026.
Exactly similar.
Huh?
Exactly similar.
Okay, I'm fixing it on 25th of May 2026.
Like. Wait, please. Capital fee has been filed today, madam, but it is only 4 and 5. 4 and 5.
What do you want?
Can it be taken out 2 weeks? If need be, I'll file a reply.
Okay. The respondent number 4 and 5 has filed the affidavit in opposition today. Mr. Endeka, the senior counsel, appearing on behalf of the petitioner, submits that the petitioner would also like to file a reply. This matter again on 5th of June 2026. In the meantime, the reply be filed.
Lordship, in this matter, we are awaiting instruction, Lordships, non-payment, Lordship.
Non-payment?
Non-payment, Lordship.
Forest? 6 months.
Verify, Lordship. Verify. We'll
Verify pay. 6
Verify.
months.
There is directive for the region bench for consideration of the interim pair of my regarding my leave.
Where? He submitted a mention memo has also been circulated to the effect. Mention memo to the effect has been circulated yesterday. What is this? How much amount?
16 crore, man. The problem is that man only this is the kind of the affidavit I have put in file.
What interim prayer you want?
At least 25% because they don't.
My goodness, that is too much. What is this? To what effect? I'm considering the submissions made by the learned counsel for a party that as an interim prayer has been made in the matter is remanded back to the to take a decision on the interim prayer made by the. Okay, you make, let me reject, again go to the division bench. Non-payment, the money you are going to for the division bench, go there again. What do you say? Let me reject it now, again let him go.
Only one, let's kind of for a moment, additional affidavit, which I have filed. It's so the clear picture that my lord, each month, my lord, we have to get 50 lakhs now. It's a non-profit organization. But they are collecting money from the different persons and they are somehow running. Now, problem is that financially very difficult to operate.
Under what provision you get this?
Well, there is a provision, the rule is there. For cattle preservation rules 2022, rules 1
But how will they verify?
Well, verification that is done by the animal husbandry department. They to verify the certificate. Even what just for number page 283, it is a letter written by themselves. 283. 2023. 283. They can send over to the total of different 50 and decision against 56. 22, 17 to 36, 23, 1,054 amount of measures for taking your 5 years. And after 1 month, we are making all the falsifications, but they are saying nothing about it. It's very difficult to operate. And what is this for my additional evidence? My additional evidence today I have Waste of 6. I give you the breakup.
Yes.
The balance is that the library gets 6 crore 60 lakh. Afterward also 7 crore 88 lakh.
This kettle has been forwarded by various police stations in Assam for maintenance. Dated so and so amount is amount. Dated so and so amount is amount. Okay, so the cattle which is being carried out, they are being sent to your place and you have to look into it.
Yes. Matter of nothing profit and or loss. It's matter of giving maintenance to the cow. Cattle. Because the expenditure is now we are getting. It is very difficult to collect from the people. So all the amounts.
You do one thing. Send those cows to this school. We'll take it. You take over.
Lordship.
No, you are under a constitutional duty to look after these animals. You take over these animals. When? Next week? Hand over the animals.
This is the Lordship. This is something different, Lordship. This is something different. The rule is page 72, Lordship. In case of siege of abundant cattle, the animal husbandry and veterinary department shall bear the cost involved in the treatment, transportation, and maintenance of the seized cattle. Now, these cattle, those are with them. These are not abundant cattle. It is seized by the police for an offense. Lordship. And therefore, after seizing that animals, Lordship, they have to keep in a preserving matter. And thereafter, they may the claimant, the owner, because basically all the
But who is
cattle.
going to maintain those?
Uh-huh.
Who is going to
Lordship,
maintain those?
Lordship, after,
Are you saying that your government does not want to maintain those cattle who have been seized?
Lordship,
Give a statement to the effect that the government does not want to maintain those cattle.
these cattle must be maintained by the government during
That-
during
That
their
is what they are
population.
doing.
Yes, now Lordship.
Are you making any payments on that?
No, that Lordship, the animal
So
husbandry.
then obviously, then take over those cattle.
No, the animal
No,
husbandry.
there you cannot, on one hand, you seize those cattle. After seizing all these cattle, you give it to them. They are a no profit organization. So under such circumstances, from where will they run these cattle? Maintain? Tell me. Give a statement out there. Put it on affidavit that the government of Assam do not want to maintain those cattle which have been seized. Let them go wherever it is. Give it on affidavit. Put the director of animal husbandry. Okay, this is not done.
The animal husbandry.
This is a
Lordship,
serious thing which needs to be taken into account.
Judicial order is clearly reflected.
No. This you have to either take it over. Take over those cattle. By next week, you take over the cattle. Give a space. How many cattle are there? Okay, take over. Give it to them.
These cattle.
You take over.
Yes, these cattle, Lordship, that was sent by the police, Lordship.
So what? You are bound. Are you saying that the police will be making the payment of the year and the animal husbandry would not do anything?
Lordship, it is true, Lordship. I have to take instruction. What is
The
the
matter has
position,
been
Lordship?
pending
Yes.
for a long time,
Yes.
2026. And there has been already an interim order directing this court to be considering it.
Lordship, before that, Lordship, I have to take some instruction regarding the position. What is
Well,
the
the
actual
notice was
position?
issued such a long time back on 4/2/2026. And for the last 3 months, you have no instructions.
Next week, Lordship, any date, Lordship, I will take the instruction.
Get the instructions
Yes,
because they cannot maintain it if they don't. They are a non-profit organization. This is a very serious affair. On one hand, you say about the cattle protection. Okay, very well. You have a Cattle Preservation Act, you have a Cattle Protection Act, all these things. And if you seize those on account of some offense and all, and you give it to them, somebody has to make the payment.
Yes. Yes, Lordship,
Then-
it's true.
And if
Lordship,
the state is not willing to make the payment, then obviously you can't give it to or endorse upon them or enforce upon them to look into it. There are thousands of cattle.
Yes, Lordship. No.
The amount comes to around, it's a colossal amount of around 16 crores. This can't happen like this. The petitioner herein is a non-profit organization. Huh? Non-profit organization who takes steps for safekeeping, feeding, medical care, and maintenance of cattle. These cattle mostly are cattle which have been sent by the police authorities after seizing them for their maintenance and safekeeping. First, it is the specific case of the petitioner that in terms with Rule 12.4 of the Assam Cattle Preservation Rules 2022, the Animal Husbandry Department of the Government of Animal Husbandry and Veterinary Department of the Government of Assam is bound to reimburse the petitioner of the costs on actuals incurred towards the maintenance of feeding, safekeeping, as well as the medical care of those cattle. It is a specific case of the petitioner that as on 30/11/2024, an amount of rupees 16 lakhs 16 crores 16 lakhs 29,460 had already been accumulated. First, It is difficult on the part of the petitioner, being a no-profit organization, to further continue with the maintenance of the capital in absence of any amount being paid by the government of Assam. The learned Mr. S. Summary, the learned counsel, appearing on behalf of the petitioner, further referred to an order passed by this court on 6/3/2020, order passed by the learned division bench of this court dated 6/3/2026 in writ appeal number 47/2026, wherein the learned division bench of this court had asked the petitioner to reiterate the interim prayer. He therefore submitted that at least 25% of the amount due to the petitioner should be paid so that the said cattle which are presently in the custody of the petitioner can be safely, can be maintained, kept, and fed. First, the learned counsel also submitted that if no payment is made, comma, it would also violate the rights of those cattle. First, Mr. So-and-so submits that he would obtain instructions and place the same before this court to list the matter for instructions on 22nd of May 2026.
Hello.
Mr. J.K. Goswami, kindly do the needful. Something
Yes,
has
Lordship.
to be
I will,
done.
I will, I will.
Otherwise, they were, you see, forget about the petitioner. We are also concerned about the cattle. Now, that day, the Supreme Court categorically mentioned that
Yes,
these cattle also have rights.
Lordship.
Not only cattle, all animals also have
Yes,
rights.
I will talk with the directors, Lordship.
Mr. Das, tell me, what is this interim order?
Installation of the alia law order matter, test secretary was. The interim order has been passed to the leave of this amount.
BTC, you don't have urgency. You have urgency.
Lordship, kindly pay the last order, Lordship.
What? No affidavit has been filed on behalf of the BTC, in spite there being a interim order.
Lordship, one instruction we have received.
No instructions. Consequently, it does not show that the BTC authorities have any urgency in the matter. List this matter again on 15th of July 2026.
June, Lordship.
What?
In the month.
You don't file the affidavit, then this can't happen like this. When there is an interim order, you have to be more urgent. Okay, list this matter again on 24th of June 2026. Interim order passed earlier shall continue till the next date. In the meantime, liberty given to the PTC to bring on record its stand. Yes, Mr. Sayavala.
I think litigation is there the page.
Huh?
Litigation matter don't have.
Which department?
PNID.
PNR.
So Lordship.
What is your
instructions
stand?
with it. So Lordship, instructions with it, kindly. Instructions are on the account of the under process.
Okay. Ms. Enbora, learned counsel appearing on behalf of the petitioner, a respondent PNRD submits that one further chance may be given to the respondents to verify as regards the petitioner's entitlement, list this matter again on 12th of August 2026. In the meantime, the respondents in the PNRD shall make necessary verifications and apprise this court by filing an affidavit as to whether the petitioner is entitled to the amount as claimed, and if so, when the payment will be made.
Similar matter. No.
What?
The period is settlement of the margin 1725 to 26. And the tender was supposed to be open on 26/8/2025.
No stay.
No one.
It's going on. What did you say, madam?
Lordship, we have received instructions. As per instructions, petitioner's bid is defective. He is quoted more than 10%.
Oh, 47.
Lordship. So, I am additional wherever I annex all the documents in the special private respondent. Your Lordship may kindly see the private respondent has not followed any criteria. Your Lordship, I have annexed all the documents of private respondent. Your Lordship may kindly proceed.
But madam, your bid is defective.
Quoted more than 10%.
You file an affidavit.
That's
Being on record.
in the meantime, the term will do.
Very good. Your bid is otherwise defective. You have quoted more than that. As per 47(1), rule 47(1) of the Assam Panchayat Constitution rules, you can't be more than 10% of the average of the last 3 years. That's the law. Under bid.
So, Lordship.
Let them file an affidavit. Miss So-and-so, Miss Enbora, the learned standing counsel of the PNRD department, submits that up to her that she has been instructed to apprise this court that the petitioner's bid was defective, as the petitioner had quoted more than 10% of the average of the last 3 years settlement, which is the requirement in terms with clause rule 47. 47 bracket 1 of the Assam Panchayat
Financial rule.
financial rules.
Rules.
Panchayat Raj or Panchayat?
Assam financial rules.
Financial rules
2002. That's it.
2000.
2000.
It is the opinion of this court that the said aspect be brought on record by filing an affidavit. The said affidavit be filed on or before 8th of June 2026. List. Be filed on or before 29th of May 2026. Liberty given to the petitioner to file any reply thereagainst. List the matter on 8th of June 2026. These matters, if you don't get a stay at the first, nothing.
I have my own. There is only one document. in the estimate.
Understood, madam. If you are not competent,
But
you can.
so not competent, but he was given the settlement monthly because
It becomes then a case. Then it's the case of PI.
then they should have my.
That is my basic understanding, man. My basic understanding is, if you are not eligible, then it is a case of PI. Too late in the day, madam. So you will say it to be infructuous.